Okay, good evening and welcome to the October 18th, 2021 Board of Selectmen's meeting. On the agenda this evening, we have public service announcements, we have a moment of silence, we will review the proposed host community agreement between the town of Sturbridge and Sturbridge Equine and Agricultural LLC. 6:35, we have a public hearing, National Grid to relocate one pole. Next, we have department reports, Building Department, DPW, Town Administrator. Then we have several, action items, consideration and possible action on change of officers, directors, LLC managers on their liquor license for Uno's Restaurant, consideration and possible action on a farmer's pouring permit for Deep Roots Distillery, consideration and possible action on salt bids for winter 21-22, consideration and possible action on establishing rates for private contractors, performing plowing for winter 21-22, consideration and possible action on the confirmation of the appointment of Andrew McDermott as a heavy equipment operator in the Department of Public Works, consideration and possible action on the acceptance of an anonymous donation to the DPW, consideration and possible action on the confirmation of the appointment of Michelle Garman as the Executive Secretary to the Board of Selectmen and Town Administrator. Old business, under which we have COVID-19 update, a review of the warrant for the October 28th special town meeting. New business, discussion of joint meeting between the Sturbridge Board of Selectmen and the Burgess School Committee to address the vacancy on the Burgess School Committee. Change of polling location request from the town clerk. Approval of the 2020 reciprocating Sturbridge Town, re-precincting, Sturbridge Town Clerk. Correspondence. Approval of minutes. We have 3 minutes. One set of minutes were held over from the September 13th meeting. Citizens Forum, and then we shall adjourn. Okay. Public service announcements. Any? Ian?
I have none.
Chase?
I have none.
Mary?
No.
Jamie?
None, thanks.
And I have none. So could we please have a moment of,
Sorry, I just got one from Leslie. The COA board will be having an open house to answer any questions for the residents on Article 46 at the special town meeting. The open house will be Saturday, October 23rd from 9 to 11 a.m. Light refreshments will be served.
Mary?
I'm sorry, I have the same ones as last week. There's 2 road races coming up, one sponsored by the Rotary Club, and the money goes to scholarships for the students and stuff. It's on the morning of Halloween, which is the Sunday this year. I'm sure you have seen the posters all over town, and if you Google Halloween event, you'll get all the details because I don't have them in front of me. But I know at 9 o'clock there's a free costume parade and scavenger hunt for children. And then there is a 1-mile preteen race, and then a 5K, which is roughly 3 miles, through OSV trails, lead mine trails. And then Home of the Brave is the Saturday after Veterans Day. And this year, we're happy to have a Veterans Fund that we established at our last annual town meeting. So the money, it went to a great cause last year, but it went to 2 veterans organizations out of Worcester County. This time it's going to be strictly in Sturbridge, and so the proceeds are going to help a Sturbridge veteran or family or 2, and that road race is another 5K. You can walk them or run. You don't have to run. You can walk, you can skip, whatever you want. So those are 2 kind of fun road races coming up.
You sure that's it?
That's it now, that's it.
Okay. Could we please have a moment of silence then for those affected by COVID? Okay, thank you. Okay, before we begin our discussion, I just want to say that there's been people accusing the board of setting a meeting secretly to discuss the host agreement. This meeting was set 2 weeks ago at a public meeting, the regular Board of Selectmen meeting. We do not set meetings secretively. Okay, Jeff, do you want to start?
Thank you, Madam Chair and Board of Selectmen members. This evening, there's a document in front of you that has been negotiated between town staff, town council, and our consultant, Will Cummings, and the representatives of the Sturbridge Equine and Agricultural Center, LLC. There are two synopses on with this tonight. One provided just recently by Jonathan Silverstein, town council, that has some estimates of revenue that he and Will Cummings have put together, in addition to the synopsis I provided with the packet on Thursday. Pretty similar in terms of identifying the relevant and the major aspects of the agreement. So at this point, perhaps some introduction to the agreement by town council.
Fine. Mr. Sullivan?
Thank you. Good evening, Jonathan Silverstein, Town Council. As was mentioned by the town administrator, we've been negotiating the terms of the host community agreement essentially since the board's last meeting at which it approved the location of the proposed facility. Assisting in those negotiations is Will Cummings, who's sitting to my left. Will is an expert in gaming economics, and I've worked with him on other gaming-related projects for other communities. So I brought him in to assist with these negotiations as well, and I think he'll be able to provide some insight into the economics of the project. I'm just going to quickly run through some of the key terms of the agreement, and then I'm happy to circle back, answer any questions the board might have. The agreement still calls for payment of 1.5% of the pari-mutuel simulcast revenue. That estimated revenue is about $240,000 per year to the town. A new term that was not in the previous version of the agreement that the board saw is an initial payment of $300,000 to the town. That's an upfront payment that would be made as soon as all licenses and permits are received for the facility. Another new term is this host community agreement calls for a payment of a percentage of sports betting revenue. So this was not in the prior version of the HCA that the board received. This is a graduated payment. Obviously, the upfront expenses of this facility are significant, and we were able to negotiate that as those capital costs got paid off, the percentage of revenue to the town would increase. So it starts out for the first 5 years of sports betting, and bear in mind it's possible that the sports betting operation would get up and running prior to the first day on which a race is held at the facility. Obviously, that's all timing that's out of our hands, but it is conceivable. And so this payment would start as soon as the sports wagering operation. So for the first 5 years of that operation, the payment would be 0.5%. So at the low end, that's estimated to be about $87,500 to the town. At the higher end of the estimated revenue range, it would be $175,000. So again, that's for the first 5 years. During the second 5 years, so years 6 through 10, it would go to 0.75% with an estimated revenue range of $131,000 to $262,000. And then beginning year 11 and every year thereafter, it would be 1% of the sports wagering revenue, which is estimated to be somewhere in the range of $175,000 to $350,000 per year. In addition to that, of course, they would pay standard permit and connection fees. Just one example, the building permit fee, if you assume, the project is estimated to cost somewhere in the range of $50 million. The applicant's representatives could speak more to that, but we're assuming conservatively that about $15 million of that would be actual hard construction costs that would go into calculating the building permit fee. And at the town's current fee schedule of $7 per thousand, that would come out to a bit over $100,000. Meals and motor vehicle excise taxes, there's a commitment to garage register any vehicles for the facility in Sturbridge. So there would be that excise tax revenue, the meals tax revenue, of course, from any restaurants at the facility. Real estate taxes, which again are estimated to be something just under $500,000. And then the other terms are the charitable donations of $25,000 annually to charitable causes in town. And another new payment under this version of the host community agreement is a payment of $25,000 annually, intended to help the town do capital upkeep and maintenance of the new fields. Speaking of which, the payment in lieu, if the town were to decide not to have the applicant construct the fields on its property and instead opted for a payment in lieu of having those fields constructed, has increased to $3 million. And we've added a requirement that the fields be constructed to the town's reasonable specifications and that they meet the minimum national standards for the various types of fields. There's a little league field, an adult baseball field, and then 2 all-purpose fields. In addition, the community gardens, nature trails, a new provision regarding outdoor senior exercise equipment, horse shows and community events. Those are some of the other amenities that would be all part of the facility and all developed in coordination with the town. So there are some mitigation provisions that are also in the agreement that were not in the agreement the board previously saw. There's, as has been the subject of a lot of discussion, the requirement that access be through a new I-84 interchange. Obviously a key provision from the town's standpoint. The requirement for the transportation management plan that has to be updated and is subject to approval of the Board of Selectmen. And there's a peer review requirement as well. And that update and approval period is for the first 5 years of operation. Public safety, there's a new requirement that there be a fire and police substation developed as part of the project to the reasonable specifications of the fire chief and police chief, and that those stations be shifted during any race days or special events at the facility to the degree deemed necessary by the fire and police chiefs. So any detail firefighters or police officers deemed necessary by the department heads would be paid for by the developer. There's also a requirement that, to the extent allowed by the Gaming Commission, the video feeds for security cameras at the facility would be available to the police department. There is a limitation of no more than 10 race days per year. That is black and white in the agreement, hard and fast. And then there's some language with respect to the treatment of horses, acknowledging that the ethos articulated by the applicants repeatedly to the board is something that the board is really relying on and accepting, and also requiring that it be really implemented as part of the operation and that it be enforceable by the town. So there's going to be a racing oversight board established by the applicant, and under the agreement, best management practices have to be employed. And if there's finding of any mistreatment of horses at the facility by the Gaming Commission that results in discipline by the Gaming Commission, that would constitute grounds for the board to suspend or rescind the host community agreement. And then there are provisions with respect to local vendors, local hiring, and supporting local businesses, both through literature at the facility and on the facility's website. So that's a brief synopsis of the provisions in the agreement, and I'm happy to answer any questions the board might have.
Jeff?
Can you just talk about CD, please, the special permit review?
Yes, sorry, I missed that. So that's also a new provision, and it essentially is a belt and suspenders provision. Of course, any conditions that are imposed as part of the Planning Board special permit process or Conservation Commission Wetlands Protection Act, order of conditions, or any other local permit is enforceable under the law through the normal regulatory process. But in addition to that, there's a provision now in the agreement that incorporates all those conditions into the agreement itself and makes them enforceable in contract. And it's just another enforcement revenue. And notable is that were there ever to be a requirement that the town enforce any provision of the agreement, the town would be entitled to recover its attorney's fees and costs as part of any such enforcement action, which is not something you generally get if you have to just go to land court and enforce a special permit condition. So it's just another level of enforceability.
Perhaps I should interject a few words about the economics before you pose questions. I started out in the racing business many years ago when it was the only game in town, and moved, as the world changed over the years, into lotteries and casinos as well. But over the course of that career, I've worked with, for, against, sideways to more new racetracks than any other man or woman alive.
Okay, excuse me, Mr. Cummings, could I just introduce you for the audience
Yes.
here and at home? This is William Cummings, he's a consultant for us.
Yes.
Sorry.
So that I was giving you a bit of my background there. And further background, I have a degree in management from MIT, and have spent my career consulting for primarily racing, other athletic, gaming, lotteries, and those types of businesses. So as I said, I've seen more new racetracks than anybody else on the planet. They're always very difficult business propositions. In part, that's because many people starting them are new to the business and have only a fuzzy idea of what they're doing. That's not the case here. These people are experienced. I have a great deal of comfort with them. I've never worked for them. I know of them only by reputation, but their reputation in the business is good. Secondly, I was mentioning the very difficult business of starting up racetracks. That extends somewhat to not only the pari-mutuel betting, but especially to the new business of sports wagering. That has taken off across the country. The applicant had a study, a very reputable firm do a study, the conclusions of which I am in agreement with, that the total amount of sports betting revenue in Massachusetts will in the midterm reach something like $350 million to $500 million. And we expect this firm, this applicant, will be a small player in that business. There will be much bigger players in the business, but we think it's reasonable to expect them to get 5 to 10% of that market. Nevertheless, those projections are subject to a wide range of uncertainty. Those are the fuzziest numbers in the document. All the others are very concrete by comparison. So I know you're not going to count this money in your budget until it gets soundly established. Please do not. It could be $50,000 a year. It could be $300,000 or $400,000 a year from the sports betting action. I think that's in brief my take on the economics of the business, and I'll entertain your questions along with the other parts of the document, which the lawyers know much more about than I do.
Thank you. Jamie, questions?
I do have some questions. I guess I'll start with that last point just made. So this is principally, the economic framing of this entire undertaking is on the sports book, the electronic sports book being passed, correct? Into the mic.
Yeah, yes, sir. Racetracks have not stood on their own. Most racetracks, there's a few exceptions, but racetracks have not stood on their own for many years. Have either slot machines or some other feature.
So I guess the question, so you're given about a 30 to 40% change in the, a range, not change, in the revenue that could occur in the Commonwealth. And then within that, you're saying there's 5 to 10% that we would hope to get to this facility. But is it fair to say that without knowing, actually, first of all, seeing that what bill gets passed and what the sort of requirements of that are, that you really can't make a specific, it can't get more specific than what you're saying here tonight, right?
Correct. I've said these are the fuzziest numbers here, and you've accurately represented, as I said, some of the risk factors involved here. I would say that like 30 other states are in the sports betting game already, and the precedents are pretty strong for how that business works and what a state has to do to make it work. So Massachusetts is flying blind here. We wound up with a pretty good set of casino legislation, so I'm reasonably confident. You never want to count on what the legislature is going to do, but I'm reasonably confident that things will shake out here as they have in other states.
Okay, so I guess then it goes to the way that I saw the economics in this breaking out, are there's really, at least as to the gambling aspects, it's the $240,000 is attributable to the 1.5% of simulcast revenue, and then, so that's a bit more specific, right? Like, you probably have a more reliable sense of those numbers?
Yes, and that is, maybe I should interject here, that as with the sports betting, most of that simulcast revenue, most of the betting on the racing here and its share of betting on racing from other states televised here, it's not going to happen here in Sturbridge. It's going to happen across the Commonwealth, online, computer or phone. What's going to be showing here is only the tip of the iceberg. So their success, their business success in both spheres is due far more to how they deal with their business online than what happens here at Sturbridge.
So I have kind of some follow-up questions there. So you going to that to what I'm looking at, I guess, is the top of page 3, paragraph 1. It's so that the simulcast revenue. Are we talking when you're saying, and maybe this is for the lawyers because it's referencing a statute, but it says simulcast revenue there, but then below it says all adjusted gross sports wagering. So can you kind of walk me through whether or not, and if it was discussed, whether or not these are gross, net? I mean, I understand what revenue is, but...
The gambling business is unfortunately rife with different terms and different segments. What the top there of page 3 refers to is not really what we economists would call revenue. It's what we call handle, and in statutes all across the country it's called revenue. It is the amount of money that people bet, of which a specified percentage is taken out and withheld by the operator. Part of that goes to the state, part of that goes to the horseman, and in our case, 1.5% goes to the community. So that is handled, that is the amount people bet.
So that's the gross?
The gross sales, as it were, because 80% of that is returned to the bettors in winnings.
Okay, so then you go down to, I guess we're to, for the purpose of this conversation, at the sports wagering community impact fee, and it references all adjusted gross sports wagering. So walk me through what this paragraph 2 means.
What adjusted gross sports wagering receipts, means is the money after the winners have been paid. This is different from what we were describing in the case of horse racing, where the handle is the amount that's bet. What gross receipts in other gambling businesses, as adjusted by this, that, or the other thing, means is the money that is left over after the winners have been paid. In sports betting, that's a very much smaller margin than it is in horse racing. In horse racing, the takeout is on the order of 20%. In sports betting, it's 1 to 5, sometimes 10%, but that's an exception.
Well, so wait, walk me through the 25%, 1 to 5 again, because I didn't understand.
Okay, you make a bet at a racetrack or,
Yep.
or simulcast on your phone. That money goes into a pool. It's called a pari-mutuel pool. The operator takes out roughly 20% of the pool. It varies depending upon whether it's win, place, show, exacta, trifecta, superfecta, et cetera, but the operator takes out 20% of that pool. The other 80% gets returned to the bettors. So if you bet on a winning horse, you might get $10 back on your $2 bet. But rest assured, somebody else in that pool lost.
Sure.
And that represents about 20% of the pool, and that is really, in technical economic terms, the receipts of the business. The town is getting 1.5% of the gross handle, the gross betting. So 1.5% of 20% would be on the order of 7.5% of the receipts that actually remain with the operator. In other gambling businesses, sports betting, casinos, lotteries are somewhere in between. But the operators and the states look at the amount of money that's left behind after the winners are paid. And those are called gross gaming revenues, adjusted gross gaming revenues, adjusted gross receipts. There's a whole host of terms for those. And those, again, depending upon the game, but for sports betting in particular, are a very much smaller number than the total amount bet. Because frankly, sports bettors demand a better deal than racetrack bettors do.
So we're getting, so boiling it down to probably a little oversimplistic, but, so in paragraph, so the simulcast, in paragraph 1 at the top of that page, which we've referred to as the handle, that's pretty much just gross betting, where the percentage comes from. Whereas when you get down to paragraph 2, the 1.5, the 3.25, and the 1%, that as they graduate over time, those are all on the net, at least towards payout. Does that include costs or anything like that too?
No,
to the facility?
It does not include the cost of operation, and that's one of the reasons why the number, we pushed, the town would like a big number there. They can't afford it. So the bottom line, I think the way to look at this is the two pots of money, the one from the simulcast betting on racing, and the other from the share of adjusted gross receipts of the sports betting revenues statewide. Those are order of magnitude in the same ballpark. The 240 from the race betting, the 82.5 to 350 from the sports betting, those are roughly, in the same ballpark.
Okay. And so is this, what was your involvement in the negotiations, if you don't mind me asking? Were you just kind of a consultant looking at, talking about what the normal industry are, or did you run numbers, or some combination thereof?
I did not run independent numbers. I reviewed the studies that the applicant had done for them, again, by a firm that's well-known and respected in the industry, and I agree with their numbers. Your negotiators had various questions along the way for what does this mean in real dollar terms, and there was some back and forth with the other side as to the import of various economic aspects of the deal.
Okay. I have other questions about other things, but it probably makes sense to stay on the economics. I don't want to monopolize.
No, that's fine,
Yeah.
whatever you have.
I mean, do you guys want, questions on the numbers?
Mary?
Well, I have questions on the numbers, but mine's kind of all together, so if you want to.
No, I
keep
don't want
going,
to
okay.
monopolize the time. I have others.
Well, we've got
Kinda like
plenty
where
of
it's
time,
going.
I mean.
Huh?
I liked where it was going.
Okay, great.
We've got plenty of time.
You're answering a lot of the questions that I had through your.
Okay, so, all right, so I think the last thing you said is that you didn't crunch individual numbers, but basically that within your experience, it looked to be logical. Is that a fair?
Well, more than in my experience, I have done similar work in other states, and the basis for their projection of 350 to 500 for the total market size in Massachusetts is based upon $60 to $90 per adult. And that is the number that I have seen in other states, and have developed projections in other states on that basis. Again, it's still too new a business to say that's a firm number, but it's as good as it gets.
All right, so then, so I guess this is, you're off the hot seat on this one.
I'll chill for a bit.
Yeah, I know, but I guess this is a larger question. I mean, what happens if horse racing is made illegal in the Commonwealth? I mean, like, so I didn't really find that to be contemplated. Did I miss it? Because it seems like we're relying on 200, that the part I was just on with the handle and the horse racing. So part of that agreement is that we're getting that, and then we have the sports book. But I didn't see anything in here other than sort of a stock separation clause, or savings clause, I should say, that would address what happens if that the revenue changes. Did I miss something? Because horse racing is not a growth industry, and it doesn't seem to be getting more popular, and I'm concerned something like that might has happened in some places with greyhounds will happen with horse racing.
It happened here with greyhounds.
Yeah, exactly. And so so what happens in this agreement? Where is it contemplated if horse racing goes away and that revenue stream to the town goes away, but we're at the other numbers on the sports book?
So it's not explicitly contemplated, but as you said, there is a savings clause. And so if there were an event that would force the horse racing facility to close, obviously that revenue would no longer be coming in. But the provision that requires a percentage of the, unless of course there were still simulcasting, because I think Will was probably just about to jump in and say there's still simulcasting for greyhound racing. But, so there might still be that revenue, but assume that all revenue from simulcasting goes away altogether. The requirement that they pay a percentage of their sports book would still adhere. Now, it might be that if they lose their racing license because racing no longer is a lawful pursuit, that they would also lose their sports wagering license, in which case, obviously, they're no longer operating, and under the terms of the agreement, if they're not operating, they don't have to pay the town anything.
Sure.
I will say, and Will may have a better take on this than I do, I think the way that the state treats horse racing is very different than it historically treated greyhound racing, and there's, in fact, a lot of legislative subsidy in the law currently of the industry. The casino legislation actually takes a portion of casino gambling revenues and uses it to subsidize the horse racing industry. So there are a lot of state subsidies that are actually helping with the economics that you've referred to and that we'll refer to with respect to it being a tough business to make money on or even to break even in. So no one has a crystal ball, at least in the near or midterm. I'd be very surprised based on where the legislature is with respect to horse racing. It's very different from where things have been historically with dog racing.
Well, I guess though, that makes sense. I guess though I do return to the point that we're negotiating a larger economic deal here, and the near or short term isn't really the concern, my concern anyways, with this host agreement, because over time we're talking about recurring revenues that could be in the hundreds of millions of dollars if this facility were effective over a 20, 30, 40-year period of time. And I think we probably, I don't know what the rest of the board would feel about this, but I think that I would need a reopener or something in the event that all of a sudden we have one huge percentage of the revenue fall away that would need to be addressed otherwise. I think that's, and maybe I'm wrong, maybe I'm being too cautious, but I don't And even the part you just said, Jonathan, about the amount of state subsidy going to the racing industry and the horse racing industry, that would actually give me concern that it would become less likely to be illegal because it is not in and of itself profitable. Now the sports, so it doesn't make sense that these things are coupled at all. It should be a sports book, and that's not, we're going down a whole other road. But, so that was just,
Let me just really quickly jump in on that.
Sure.
So we certainly discussed reopening provisions. The problem with those is they tend to go both ways. And when you start talking about wanting a reopener, then the developers start wanting MAC provisions, materially adverse condition provisions, that if the economics of the industry changes such that it represents a materially adverse condition to their EBITDA, then they're going to want to come back and cry poor and reduce the revenues. And in my estimation, it's usually better to get a deal and know that that's the deal that's going to pertain, rather than trying to reopen based on speculation about what may or may not happen. Obviously, if the horse racing industry were to go away and there were to be literally no simulcast revenue, then the town would be getting less money. It would also presumably be having less impact because the facility wouldn't be open, and you'd be getting just sports wagering revenue, which would be almost entirely based on what people are doing sitting in their living rooms. This is a policy decision, obviously, for the town to make, so it's not for me to say, but I just thought I would put that out there.
no, I understand, that's logical, thank you for that. But it's just because that, at least on this part of the contract, if I'm reading it correctly, that this is estimated at 240, and then, which is still the...
Let me add one
Oh, sure.
point to that. We have a precedent here, not only in this state, but many others, that have outlawed dog racing. No state has prohibited horse racing yet. It might happen, so that's speculation. But all those states, including Massachusetts, that have outlawed dog racing live still allow betting on it by simulcast. This money comes from the simulcast revenue. The possibility of the state outlawing simulcast betting on horse racing, in my opinion, is infinitesimal.
Okay. All right. Thank you for that. The next question I had was on the I-84 interchange. So, has there been any process in terms of any guarantees from the Commonwealth about getting access off the highway or anything like that?
Not to my knowledge. I think Mr. Stefanini could speak to that better than I could. We've not engaged with the state at this point. I think it would have been premature until the HCA is approved, if it is, and the zoning is approved, if it is. All I can say is that if they don't get it approved, then this has been an exercise that won't result in a facility being constructed, because without it, there won't be a facility. So,
Jamie, you remember at all the hearings, they mentioned different pieces.
Sure.
And if one piece doesn't come together, then the project doesn't go.
Yeah.
And this happens to be one of those pieces.
I understand that. Well, I guess but I just was looking to see if there's an update from the other one. I'll let some other folks ask some questions for a minute.
I'll jump in, because I have a lot. So I'll just start with an overview of my impression of the contract, of the host agreement. I thought it lacks specificity in a lot of key material terms. I thought it was very general, has no commencement start date, for example, after obtaining a license, unlike a lot of, well, let me just back up for a minute. So we don't have any host agreement to refer to in Massachusetts because It's not even legal in Massachusetts yet, but we're moving ahead with the host agreement and a bylaw in advance of something being legal. So I went to some of the host agreements with respect to the casino when they were issued 3 licenses. Well, I guess there's only 2 now and 1 harness because one isn't open on the Cape. But they had a lot more specificity in their host agreements, and I just see it lacking here. They have, well, we should have done, in my opinion, and the way it's been done in other communities, we should have ordered our own studies, not, and this is no offense to our consultant, he has, amazing credentials, but the economic impact study, the traffic study, noise mitigation, those are all ones that we should order at the applicant's expense and not just have a consultant reviewing studies that were done by the applicant. We should do them up front and then use that data to mitigate in our host agreement. And I think that's how other communities did it. They had their studies up front, because otherwise, we don't know, we don't have the data to accurately mitigate. So I do object, I guess as a matter of policy, that we are relying solely on the applicant studies and, with all due respect to our consultants saying you find them top-notch, I still think the town should have chosen who they wanted to utilize. We should have analyzed our own data first and then moved forward. So I feel that way, and I feel strongly that without that traffic study, I think that was wrong. I'll move on.
Would it be helpful if I just...
Oh, yeah, sure. If
issue?
you want to take it step by
Sure.
step, that's great, because I have a lot more that I would like
Sure.
to discuss.
So there are 3 gaming facilities open in Massachusetts.
Correct.
So there are 3 host community agreements for those 3 gaming facilities. I negotiated 2 of them.
I know.
I negotiated Everett, I negotiated Plainville. Everett, I'll note, was a $2.5 billion facility, 100 times the investment of this project, essentially, in terms of physical construction. Obviously, and it's in an urban center on the Boston line.
Yeah, well, let me
So-
interject. As far as that goes, I think that cuts the other way, because we're going to be more impacted in a small community, taking on 2 types of gambling, if you will. So with all due respect, I think that cuts the other way. I think the impact is greater in a smaller community with respect to our quality of life and the perhaps level of disruption with respect to traffic, et cetera. So I totally get the size of the,
Sure.
was much bigger.
But I can also speak to what was done there,
Right,
because
right.
I was involved in it. So the other point I'll make is all of those impacts are the result of everything happening on site, whereas a lot of the revenue coming from this facility, of course, has been discussed, is not from activities happening on site. There was a much different lead time going into that project, of course, and I understand that's a fundamental policy issue.
Again, that cuts, they had more lead time, more preparedness.
But
We have less.
there they were able to, and I don't want to speak for the applicant. As I understand it, if this was going to happen, it would have to happen now, because if they don't get a racing license now, at the time that the sports betting legislation is presumably close to being adopted, which is, of course, an assumption that has to be made, then they won't, that's what gives them the trigger to apply for the sports wagering license. So if it doesn't happen now, the argument would go, then it's not going to happen. That wasn't the case in Everett or in Plainville,
Well, I
because
know.
we had that lead.
We don't have the lead time, I get that, which,
So-
again, is
But
an
what I-
area of concern for me.
What I will say is all of the due diligence that you're talking about will be able to be conducted
I get
prior to a discretionary special permit.
I get it, but again, for the record, that due diligence should be done ahead of time. It's not our fault or issue that, time is of the essence. Due diligence is due diligence because it's done before a contract is signed. Due diligence loses its definition if it's done after the fact. So I'm just going to leave it at that, and I'll just move on with some of my concerns. It would have been good if this agreement had a section on events of default. What happens when there is a material breach of contract? A lot of these other ones that I've reviewed have an area called events of default. And if they don't meet certain time requirements for building, they start paying by the day sums of money, and it's called, a default. We don't have that. The only time we even discuss it is that if after 48 months they don't obtain their license, we can terminate the contract. That's it. We don't talk about anything. I mean, as far as the 10 days of racing, what are the consequences if they attempt to have more than 10 days of racing? Is that considered a material breach? Can we rescind the host agreement? Can we issue a cease and desist operation because they're going into 11 or 12 days of racing? All these things, at least when I have practiced, are kind of the things that one would spell out in a contract. And I just don't see that spelled out anywhere.
Can I speak to that one issue?
Well, you know what, let me just go through the whole thing, maybe, Jonathan, because...
Sure, absolutely.
Okay. I think it was also lacking specificity and detail with respect to access. I think there's like 4 lines that talk about it, that it's I-84. I've got one host agreement that was negotiated for the town of Milford, okay? It's 160 pages long. In their exhibits, they lay out exactly how access was going to be obtained on I-494 and Route 16. It goes on for 4 pages. It has a level of specificity so that it can be enforced. Right now, there's nothing to enforce, even if we wanted to. It's about as general as you can get. Access will be through I-84. I mean, okay, where, how? I mean, I'm going to pass this other one out to the board afterwards, because I think that this is a good example of a town that really did its homework with respect to what they did before they signed a contract.
May I ask a question?
Yeah.
What town is this?
This is the town, and I intentionally chose a town because I thought people would say, because I have the summary host agreements for Suffolk, Boston, Suffolk, Revere, Brockton, Taunton, Springfield. This particular one is Milford.
My point is, that didn't work out.
They didn't get the license, but they were protected themselves in the host agreement. They weren't the ones that ultimately...
You don't know how it would have worked.
Well, we never do. But as an attorney, right, you prepare for the worst and hope for the best. But that doesn't excuse a contract that doesn't have detail. Because that's how parties, when they break up, if they break up, end up in court trying to say, what the heck does this mean? And I don't think the town of Sturbridge...
I'm sorry to interrupt you, but 10 days, you expressed a concern about 10 days of racing. The document says 10 days of racing.
It doesn't... Yes, but with all due respect, 10 days of racing, what are the consequences? They can say that's a minor breach of contract. That's a material breach. It should be spelled out. What are the consequences?
You can say that about any term in any contract.
Yes, and that's why typically contracts are extremely specific. I'm not going to get into a debate about this. I mean,
I like the contract language to the lawyers.
And I am one as well. So I think it's very general, and that's my opinion. Reasonable minds can differ. I've seen other contracts that are more specific, and I, for one, would favor those, because when they're general, that's when you end up in court. Adding 1 day of racing, oh, that's not a big deal. You know, we'll add X, Y, and Z. And the reason I'm stressing that is because there's a lot of people out there, and we represent residents of Sturbridge, that are depending upon certain promises like 10 days of racing. That's why I want it to be clear that's material breach. But with all due respect, we know that can change just like that. This is a contract. Amendments change all the time. Our host agreement on our cannabis changed. So host agreements, by mutual consent of the parties, can change. So it can be 10 days in the first 2 or 3 years, and then if and when horse racing takes off again, because right now, it's, I think, almost entirely subsidized by that horse racing fund. They're the ones who come up with the purse money. And so right now, there's probably purse money for 10 days. But when a business is successful and you have a love for a certain sport, I would, if I were a betting person, say in 4 or 5 years, or even 3 years, if 10 days takes off, we'll be right back here asking for more than 10 days. And so
Every day of live racing they conduct, they lose more money.
that can, right. So what I'm saying, there are residents who it would be a deal breaker for them. They may support this because they think it's 10 days. And as I said, it's going to start off at 10 days. But that would be another.
My question is, why would they want to run more than 10 days?
Well, it's not our,
It's not, I'm not going to answer that. That's not my, Saratoga runs more than 10 days. I'm not going to speculate what an applicant would or wouldn't want.
You're speculating about what can be covered in the contract or not.
Look, this is our opportunity as representatives of residents, and we have a chance to say what we like about the contract and what we don't. I don't like the lack of specificity about access. I don't like not having a default section in the contract. In terms of the financial aspects of it, and again, you're going to say these are much bigger deals, and I get it, so that's why they're 10, 15, $20 million. But the percentages that have been negotiated are lower than the percentages that were negotiated in the casinos. And I guess I personally don't understand why. I mean, the town of Sturbridge is going to be incurring that risk of not knowing what sports betting will do, okay? We're told that 90% from the UMass study is on your phone. I'm not going to dispute that. But the real number is how many people will engage in sports betting and how many people will engage it at the facility, okay? That's what is going to be a negative impact for a lot of the people who live here. Some may love it, but people contacting me do not, So I think those percentages are low. And again, we don't have another contract for sports betting in Massachusetts to look to. So I can only look to the casinos, and I don't know, they're coming in at 2%, 2.5% of gross gaming revenue. I don't understand why the simulcast is at 1.5, but then when we get to the sports betting, we never exceed 1, and that doesn't happen until years 6 through 10 of operation. From what I'm told, sports betting is the best thing since sliced bread in terms of revenue. So I'm wondering why we're starting at 0.5%, proceeding to 0.75%, and then making it to 1. I would suggest a more reasonable percentage to protect Sturbridge, and the fact that we're going to be the test case with a sports book and a racetrack, the only one in New England. I would suggest we start at 1.5, we go to 2, and then we go to 2.5. I don't understand why we are that low. And in terms of the upfront, $300,000, I think that is also very low. It says within 30 days after receipt of all licenses and permits necessary to operate the equine center. We don't state what those permits are. Others say after the first building permit is issued from the town, and they call that the building permit issuance date. Under this reading, we're going to have to wait until they get permission from the federal government and the state Mass DOT for their access through 84, which we still don't know exactly where it's going to be. So, I mean, we're not going to see any money at all for several years, and then it's going to be $300,000.
Well, they're not going to pull a building permit before they have the I-84 access, so that'll actually happen much earlier.
I hope. I mean, we don't, again, we don't know. We haven't been shown even a sequence of we're going to get this first within X amount of days after a license. How about language like that? Within 30 days of being issued the sports license, not the sports license, the license for the horse track, which they filed on October 1st, we will do X within 30 days of getting the license for sports betting and the racetrack, because I understand by looking at the various bills, that's one category of license. Horse track combined with sports betting, they're entitled to one. What are they going to do within 30 days of being issued that? Those are the kind of things that I think need to be spelled out. And again, if this is going to be a $50 million operation to build, and it's got the possibility of 5 to 10% of a market that is thriving in the various states that pass sports betting, I don't think the percentages are enough, and I don't think that upfront community benefit payment is enough. Moving on, right now, the only way we get out of this host agreement is 48 months after being declined a license, okay? In 2 weeks, we could be going before our town. I really don't know how it's going to come out. It seems to be splitting our town quite a bit. And it's a 2/3 vote. I don't have a crystal ball, and I'm not going to try to have a crystal ball. But if that doesn't go forward, we need, where is the lane? First of all, I think we would be foolish to sign this before town meeting, before we know what our residents want. I think it would be not in the best interest of Sturbridge, but that's going to say that. If this gets signed before, and then they vote it out, we got to get out of this contract. And right now, it's not. We don't have an out. And so they can come back by petition, perhaps, at annual town meeting, and present that zoning change again. We are bound by this host agreement for 48 months from the date of signing this. It only hinges on the license. There's nothing in here that hinges upon the outcome of our special town meeting. And to me, that's not protecting the town very well. We should be able to, if our townspeople vote it down, then this host agreement should, by its own accord, be null and void. That's another aspect that I don't agree with. Hold on. Financial percentages, areas of ambiguity, failure to have a start date. And then there's other contracts, like Milford, for example, that has a whole section on protecting those, the financial impact of protecting those who are maybe adversely impacted based upon their home values. They have an area where the applicant, in that case a casino, but we'll have a sports bar. I don't think a lot of people who are in that immediate vicinity planned on that. Maybe their property values will go up, but chances are, when you add an overlay with gambling and a bar, chances are the house that's next door is not going to like it a mile away. So anyway, they have an escrow account where they pay in a percentage, not going to read this verbatim, and in the event they sell their home and it's shown by whatever formula this attorney and consultant worked out, they are paid through by this fund to get it to fair market value to the extent they're adversely impacted. And I think that is another area that this board, as a policy matter, should pursue further. And if you want, I can show you the host agreement that protects the people who live within that neighborhood of Milford. And I think that's also in Springfield's document, but I could be wrong. I don't want to. But as I would say, that's something else that we should look at as a board. Finally, in terms of damages, I know a lot of them have liquidated damages of X amount, and I don't know, what your feeling is on that, but it seems
This has a liquidated damages provision.
Yeah, a lot of them do. And
This one does.
Okay, where is that? I'm sorry, I missed it.
Section 29.
Okay, thank you. And what is the amount?
It's $1,000 per day.
Okay. Right, I didn't see that. $1,000 per day.
Per violation. So if they're in breach of multiple provisions, it would be multiples.
All right, I'm going to have to review that. My apologies on that. I did not see it, and I'm going to have to look at that a little closer.
you mind if I?
Yes, go ahead.
I'll give you a little break.
Jump in.
All right. Do you mind?
At
All right.
some point, sorry to cut, at some point, it would be great to be able to sort of address some of the points that were raised.
I'll let
Yes,
you,
yeah.
while it's fresh, do you want them to address it, that?
Yes, Jonathan, go ahead.
Sure. I mean, there's a lot to unpack there, and I may miss some of it. Events of default. I'm familiar with, the same lawyer wrote the Springfield and Milford agreements. And quite frankly, they're, in my view, they're very long. And I know that in each case, that law firm charged over $1 million in legal fees during the process. It's not my approach. I'm not saying one's right or wrong. I will say that for this project, which is on an order of magnitude far, far smaller, it didn't seem like an approach that made sense. The event of default provisions in those HCA's, in my mind, are overly complicated and don't do anything more than a breach of contract action for which, in those agreements, they don't recover their attorney's fees, but in this one, the town does recover their attorney's fees. So the incentive on the party with whom the town has an agreement is much stronger to try to reach accord when they're going to be paying the town's bills. But if they win in a breach of contract suit, we don't have to pay their bills. On the issue of the percentage, I just don't think, and Will can speak to this much more authoritatively than I can, you can't compare the percentage of gross gaming revenue in a casino to the percentage of gross gaming revenue when you're talking about the sports book. The sports book is what is going to be paying the bills for building the Equine Center, which is the only way in which they get the sports book in the first place. And Will looked at the economics, he considered the economics. The economics of a casino are very different. They're much larger margins. And you're starting with a much larger pot. So yes, I negotiated 1.5%, graduating up to 2.5% for Plainville. Not on sportsbook, but rather on their slot machines. To tell you about the margins in slot machines, 50% of their gross gaming revenue is going straight to the state. Plus the 1.5%, now 2% going to the town. So that tells you about how profitable that business is. It's different, and I don't think you can compare the two. And I think what you should compare it to is what percentage of the sports book will FanDuel be paying to any community? 0. None of the other players in this market will be paying any percentage of their sports book revenue to any community. There won't be any host community. The only one that will be getting it is Sturbridge. Possibly Plain Ridge, that's a whole different question. But again, they have their casino that is propping up their whole operation.
Can I just ask a question off of that? So if, like, Wynn in Boston gets a sports book, their host community agreement is already negotiated, so that sports book is not going to add revenue to what Everett receives.
Everett's not taking a percentage of GGR at all.
Okay.
They're getting flat fee payments. But yes, you're right.
Okay. So it would just be for Sturbridge because basically it's a startup.
That's right.
With it, yeah, okay.
I was curious, about FanDuel and about other ones. How do they plan to compete against well-established big companies that are already doing business now?
I don't want to speak for them, except to say that I think it's going to be a niche market, and they're going to be pursuing a different type of wagerer than FanDuel. But I don't.
Right, and many other states allow fairly wide open competition, and 20 to 30% of the market goes to the smaller players.
If the zoning fails at town meeting, yes, there's no explicit way to cancel the agreement, but the agreement's dead because they need the zoning. Yes, presumably they could come back.
It's not dead,
and-
Jonathan. It lives as long as for 48 months, they can come back to another special town meeting or annual town meeting. It's not dead.
So for 48 months, they would need to get another favorable recommendation of the planning board, because state law requires that to happen. And if they get it, yes, they could come back.
Well, by
to-
petition, they can file by petition too, can't they?
No, under Chapter 48, Section 5, if a zoning initiative fails, unless it's recommended by the planning board, it cannot be brought back for 48 months. So.
Including a petition of 100
That's
signatures.
correct. Town meeting may not approve it. So if the town wanted to put it back forward and the planning board was on board with it, then yes, it would continue to bind the applicant. And if the town was successful in that, the town would still be a party to the agreement. I don't know why that would be viewed as a bad thing, but certainly if the town wanted to have a provision that said it could only get one bite at the apple, then I'm sure the applicant would agree to it. But I'm not clear on how that somehow ties the town's hands, given that under state law, it cannot be brought back unless the town supports it, the planning board supports it, for 48 months. Financial impact to home values. Again, this is not a $1 billion casino. I guess a couple points. Chapter 23K, the State's Gaming Act, required host community agreements for casinos. There is no requirement for a host community agreement for a facility like this at all, except what you make of it. There are $25 million projects all over the state that are built that don't have host community agreements, that don't have, these surrounding neighbor impact agreements. I think those impact agreements are rife with problems in any case, and I don't know in this circumstance that it would pertain where the traffic, which is the primary impact, is not going to be via local roads. And to me, it's crystal clear. We don't have the design, obviously. That's going to happen further down the road. As I said, the planning board conditions are going to be made part and parcel of and enforceable under the host community agreement, which none of those other agreements had. I just don't think you can compare them because they are not, this is not a casino. And I think and I said this at the last meeting, there's a fundamental policy decision that has to be made here. It has to be made up front. Do we want to support this project in the town and the potential benefits it brings, knowing that the timing is such that some of the things we might want to do now, we're going to have to wait and do before the planning board issues a discretionary special permit that it has the absolute right to deny? Or do we want to say, no, these unknowns are too scary for us, we don't feel comfortable with it, and so we're just going to say no? But I think it's a false choice to suggest that we could do all of this due diligence up front and still maybe end up with a project. If the decision is made that all this work has to be done before you sign a host community agreement, I think you're essentially making the determination, which is a legitimate determination, policy decision, that you don't want the project. Because if you decide you want the project, you have to accept the timeline that is applicable here.
Can I jump in? Could I jump in?
Of course.
Yes, they're policy decisions, and you already know how the board feels. It will probably move forward. I do want to just, I'm not going to go back and forth. I am going to take a little bit of issue saying, it's totally, this is casinos on one hand, sports betting is totally different on the other hand. the casino market has gone up and down. A few years back, Foxwoods needed help. I understand now Springfield's not doing great, whereas sports betting seems to be on an upward projectile in all the states. I haven't seen evidence that it's up and down. Maybe you have, and if you can, I'd love to see it.
No, it's been straight up so far.
Okay, that's right. So it's been straight up.
So were casinos in the beginning.
In the beginning, I get it. So to say that that's a basis for not increasing our percentage of gross gaming revenue, to me, it just isn't a convincing argument, because casinos have been up and down. And the fact that they give 50% to taxes to the state, to me, just cuts the other way. They're giving that, and they're giving 1.5% or 2% back to the host community. So those arguments, to me, go the other way. I think that we would do a disservice not to try and increase those percentages. 0.5%, and then only getting after 6 to 10 years to 1%, I think is really a disservice to Sturbridge, especially when looks like we're gonna be the first test case for being not only a racetrack in New England, but carrying a sports book and having a sports bar. And then to start the percentages that low when we're incurring those kind of unknown risks and being a test case, to me, cuts in favor of increasing. And if anything, higher than what casinos get. But I'll settle for what the 1.5 to 2 that casinos get. But to say all of those factors should lead us to have less, to me, is just really, to me, that's unreasonable. And perhaps people need to give that a little bit of thought. Because sports betting, if it takes off the way it should, even with 5 to 10% of the market, Sturbridge is not getting a fair amount, in my opinion.
Can I ask you a question, Madam Chair?
I was going to check here, and
I'm sorry, but it really was factual.
Yeah. All right. My question, and I'm going to read the summary, I just kind of have a question. Athletic fields. Developer will construct 4 athletic fields, 1 adult baseball, 1 little league, and 2 multi-purpose on its land to the town's specifications and donate the fields to the town. Then the next sentence is, the town may elect instead to have the fields constructed on its land or to accept a payment in lieu of $3 million. Is that a one-way street?
Yes.
So the town has the power to say, no, we don't want the $3 million, you have to build those
Yes.
fields? Okay, good, that makes me feel good. And the question that I had that was answered tonight was, what was the approximate sports betting number? And that document was given to us tonight. The community impact fee. The police, I would think, would be the biggest community impact that we have. If we need additional officers or whatnot, and that community impact fee of $300,000, that could be used on police and fire?
So the answer is it can be used for anything town meeting decides it wants to use it for. However, any police or fire personnel required for the facility will be paid for above and beyond all of these payments by the facility.
Okay, so that's separate then?
That's,
Yeah, like if they need a detail, they're going to pay for the detail?
That's right.
or whatever. Okay, all right, great, thank you.
Okay, Ian?
With the fire and police facility, would that include equipment necessary to fight fire based on it? And, I know the chief's not here tonight, but if there would be special equipment required, for the facility or whatever goes on, I assume that would be included in the cost of building that?
yeah, probably not a truck. But it would include communications equipment and whatever other equipment.
And do they implement their own fire prevention teams? I know a lot of large commercial facilities have, trained people on site to work alongside a fire department in that event. Would they be doing something like that too?
So that's spelled out by the Gaming Commission for casinos. We're not there yet for this facility, but I imagine that will be required, and if it's required by the chiefs, then it could be required through the planning board special permit process as well.
And then also for the on-place sports book, it would be subject to the standard liquor law operating times. So unlike a casino that can operate 24 hours a day, 7 days a week, they would be opening and closing on the same time frame as any other bar or restaurant?
That's right.
Within Sturbridge, correct?
Right.
Depending on.
In regards to impact, when you look at casinos, they're open 24 hours a day. That leads to a lot of odd times, people coming and going, and a greater community impact. So a regular bar, like we open, 15 of in town, it'd be about the same impact as a regular bar, correct?
Yeah.
Time frame
Some
wise?
of those casinos, Ian, in Connecticut, aren't on municipal.
Yeah,
land.
that I know, yeah, it's Indian, or
Indian.
Native American land, but,
In Massachusetts, they also can apply for extended liquor service
yeah,
from the Gaming Commission.
right, right.
And again, going to impact and risk and what the risk is, and part of what, there are two aspects that drive what impact fee a community can negotiate. One is, what are the impacts it's going to experience, and another is, what are the economics of the facility? How much can they afford to pay, and how much should they pay because of anticipated impacts? So, as I said, the impacts of a casino are 100% on-site. It's impacts of people coming and going in person from the facility. Whereas the impacts of this facility, other than the 10 race days, which is a hard and fast number, would be people coming and going from the sports bar, and perhaps betting there, or perhaps going to any other bar in town and betting from there, or playing Keno, or whatever other type of activity they might engage in. So it's going to be a typical sports bar, and you don't see most typical sports bars paying impact fees of tens or hundreds of thousands of dollars a year to the community.
I agree. I'm good, yep.
Okay. Mary, anything else?
I think I think that, I don't know when we're going to close this, and if people are ready.
I'm agreement that I don't think it should be closed today. I think there's a lot of questions that
There's a lot
are
of
left
questions.
unanswered in more.
I am going to put this out there, it's, and I'll form it in a motion, but, we have been told early on, this is one of the best things that ever happened to Sturbridge. Some people have talked to me and think it's the worst thing that ever happened to Sturbridge. Most recently, it was corrected, I believe, that not only this one of the best things, one of the advocates said it is the best thing that has happened to Sturbridge. I'm not going to try to change anybody's mind. That's not my position. We all get one vote. But we do have a duty to make that host agreement as strong as we can, not ambiguous, because that's how you end up in court, okay? And I also think everything that was said, with us being the first one to undertake a sports book and a racetrack in our town, rezoning agricultural land, those percentages don't accurately reflect the kind of unknown risks that we're taking. And also, as Jonathan pointed out, it is a policy thing that our due diligence couldn't do the noise mitigation, the economic impact, the traffic analysis. I mean, no traffic analysis before we sign the host agreement. Usually, your numbers are based on your traffic. You mitigate based upon the results of your traffic study. We are jumping the hoop for the applicant. We're going beyond that. We're saying, well, we're going to have to do due diligence after the fact, which is an oxymoron. But anyway, all that should be reflected in the kind of percentage that we get. And to end with 1% after 6 to 10 years is just not a good thing. So I hope everybody thinks about it. But what I would like, getting back to the best thing, the worst thing, if you went to a doctor, you're going to go, they're two excellent, attorney, consultant, fine. You get a second opinion sometime before a big surgery. And I think this is one of the biggest things to happen to Sturbridge, one way or the other, in terms of quality of life. Those who want it, those who don't. I think that it would be prudent of us to take their best effort of the contract that was negotiated and seek the applicant to pay for an additional second opinion from another gaming attorney who also focuses on this as his or her area of specialty within the law. And just like doctors, they embrace that, a second opinion. And I think that given our willingness to really rush through this in terms of not having the traffic study, not being able to do our due diligence, we at least should go to another gaming attorney, show them this host agreement, and say, what do you think? Do you think these percentages are fair to Sturbridge? Can you think of anything else to protect our interests? I personally think that we owe it to our residents to get a second legal opinion. So after everyone thinks about it, I'm going to make a motion and either thumbs up or thumbs down to it, but I am going to make it for the record.
Okay, first of all, did the proponent have any questions or answers to questions that were raised? Okay. Okay, now, this is not a public hearing, but it is a public meeting, and I know it's a big issue. Is there anyone in the audience who has a question on the host agreement? Okay, could you come up to the mic, please? Identify yourself and give your address.
Hi, Joanna Shapiro, 50 Westwood Drive. A quick question is regarding the host community agreement that the Board of Selectmen has the ability to enter into with the applicant. There's a lot of misinformation out there that says that this is an agreement that cannot be changed. And I believe that this is something that the Board of Selectmen could change if the developer comes to you wanting more races. And, you know, we all know all the misinformation on Facebook, but this is a big one that our own committee members are perpetuating, not this board, but other boards are perpetuating, saying that agreement can never be changed. And I want that clarified for the record.
Okay, Jonathan?
Sure. Any contract can be amended by agreement of both parties. So if the town decided it wanted to allow more race days at some point in the future, and the applicant actually wanted to offer more race days at some point in the future, both of which seem pretty unlikely, but within the realm of possibility, then they could agree to revise the host community agreement. That, of course, assumes that any special permit from the planning board doesn't have that condition. If it does have that condition, which I'm assuming it will, then the planning board would also have to agree. So as with anything, if everyone in the world with a decision-making function agrees that something should change, it can change.
I appreciate that. And I realize that tonight we're talking about the host community agreement, but very related to this, you know, we were talking earlier at this meeting about what would happen if horse racing is abolished in this state. And I've asked a couple times at other public hearings about this question, and our zoning bylaw that we're going to be voting on specifies that races must occur on this property. And I don't understand what the fate would be. You know, we're talking about finances here. What would happen if horse racing goes away, and maybe simulcasting stays, maybe simulcasting goes away, but our whole zoning bylaw disintegrates if horse racing is abolished, or if horse racing is no longer financially reasonable for the developer.
Yeah, I think Jonathan already answered that, but could
Well, it's a little bit different.
Right.
No, it's a slightly different question. So you're correct. The current version of the zoning bylaw requires that there be a certain amount of horse racing. I think it's 6 races every 18 months. That was a policy decision that the town made.
When you say the town, who is the town? Because we didn't.
Well, in
Board of
working
Selectmen
with
didn't.
town staff, professional staff, when we
I'll
drafted.
admit to it.
Okay, I just want to know.
No,
It's
and let
usually
me-
policy set by the board.
Let me just say why. We didn't want, if they were going to do horse racing and needed to do horse racing, we didn't want one race one day, and then they got a sports bar, and they got all the other amenities on a piece of agricultural property. They had to actually race horses in order to comply with the bylaw. That was the bread and butter of the project. Now, if they only want to race one day a year, you can change the bylaw to say that, I guess.
Right.
But we didn't want this to be a subterfuge to get a sports bar and some other commercial amenities in the middle of an agricultural property.
Around the country, there are far more places which have issues with places masquerading as racetracks, and only running one day a year and getting the benefits thereof for the other 364, than vice versa.
So I think that was the concern that fueled including that provision. Again, town meeting or can decide to take that provision out or revise it, either now or in the future. If racing is ultimately outlawed, then obviously that provision would need to change.
So I just see that as a fatal flaw with the zoning bylaw amongst many others. But another question I have, our town attorneys estimating or describing our on-site impact as only those 10 race days. There's going to be impact all year, horse trailers for training purposes, hay, all sorts of large vehicles, trucks coming all the time. Horses come and train all the time, not just 10 days a year. And there's also festival days, which I believe means claiming horses. There's lots of other activity going on than just the 10 race days that are going to impact this community on site.
I don't think I said there would only be impact 10 days per year. I don't remember making that statement or referring to it. What I said was that when we're talking about a percentage of the sports book, the impact from the sports book is the very small percentage of patrons of the sports book who are coming to the sports bar to wager on the site. So we're talking about an impact fee percentage for the sports book, which is by and large going to have no impact on the town at all, and comparing it to a percentage received by a community that hosts a casino, where every dollar earned is from someone coming to the facility. And so you're going to have, hundreds of thousands, millions of people coming to the Wynn Casino in Everett every year. That has a much bigger impact than the number of people who are going to be coming and patronizing the sports bar to place wagers on site as compared to the percentage of revenue that's being paid to the town.
I don't dispute that, and maybe I slightly misheard you, or I don't know if any on the Board of Selectmen heard, but what I heard was that at this facility, the on-site impact would be limited to those 10 race days, and I just want to be very clear that that's not the case.
No, I didn't hear that at all.
Well,
Plus, there'll be other activities on non-race days, even on race days, so, that could not have been said. Okay, Mary, you have a question?
I just want to add to your question and the answer that you received from town council to just say reasonable minds differ. I know Jonathan just said the sports book will have no impact at all, and that's actually not true. I mean, as a resident that lives here, 10% will be on site, and at this point, 10% of a big number, because sports betting the projectile is up. People like to, which is fine. But 10% of a big number is a big number. We don't know that. So to say the sports book has no impact at all would basically be saying that 100% of sports betting will take place on your phone and nobody's going to go to the bar, and that's just not true. So it will have an impact. Perhaps not like a casino, but to say no impact at all, I don't think is a fair statement.
Sorry, again, I don't think I said no
You
impact.
did. You said sportsbook will have no impact at all for the town. I wrote it down when you said it.
I think what I said was the people who are gaming from home aren't going to have an impact on the town, and the impact will be the people who are actually coming and placing wagers on
10%,
site.
Maybe.
How many kiosks are going to be on site for sports betting?
I don't know the answer to that, but far fewer than the smartphones that exist in the Commonwealth.
It's not written in the host agreement.
Okay, I thought I heard it in the hundreds.
Financial projections are that about 2 million of the sports betting revenues will come on site. The other 33 million, if we're talking a number of 35, the other 33 will come from off-site. So that's a little under 10% will be on site. Their anticipation, again, these numbers are all up in the air.
Okay, and I don't have the exact number, but I remember being a bit startled when I read somewhere the number of kiosks, but I don't want to misrepresent the number. And one other question as well, and I'll leave it to other people, but in terms of the impact, we are comparing casinos a lot to racetracks and sports betting. You know, I'm wondering if we've got any figures. My understanding is that racetracks have a much higher correlation with organized crime than your typical casino, but that could be false, but there's definitely organized crime that typically comes along with these types of operations.
No, not anymore.
Just flat out, no crime at all.
Flat out, no.
And Ms. Shapiro, you're getting off the host agreement.
Well, one
okay?
consultant did order a crime study
Okay.
as part of it. And
That
there
goes
is
to
an
the impact.
article in,
People are concerned about the
Right.
crime, but the data show
Doesn't.
there is no significant increase in crime with any of these facilities. Both racing, gaming, and state lotteries, for that matter, are regulated by state agencies whose mandate is to keep out criminal elements.
there is an interesting article in Forbes.com about sports betting and taking a second look with respect to some states having some difficulty with organized crime. If you, according to this, and I read Forbes, so
Yeah.
Forbes.com has an article on organized crime and sports betting.
Okay, I appreciate it. I'm done at this point. Thank you very much for entertaining questions.
Okay, does anyone have a question on the host agreement? Don?
Don Miller, 501 Lead Mine Road in Sturbridge. A couple of questions. The first one is, I'm confused about what the actual negotiating process is. Who is actually involved in the process representing the town? Is that you? Or
Our town council, our town administrator,
our town council? Is he here? Is it-
he's sitting right there.
Okay, I wasn't, okay, just wanted to be clear.
So-
And who else?
Me?
Okay,
In,
And the town planner,
okay.
And Will.
I'm a hired gun.
yeah.
I thought so, yes. Okay, the host agreement should provide adequate assurances that all of the promises that the applicants have made are fulfilled, or else there would be some sort of penalties. I think there should also be in there some timeline of when things will be accomplished. And I realize they can't set a specific date at this point, but they can say that after 2 years of receiving all of our required licenses and approvals or whatever, once they've all been attained, within 2 years, the athletic fields will be completed. There should, otherwise, I don't know there's a real good way to hold people accountable for fulfilling the promises that they have made.
You want me to speak to that issue?
Yes, Jonathan, please.
They cannot apply for a certificate of occupancy until the fields are completed. So they can't commence operations until the fields are completed. So that's the best insurance that you can have, and that's written into the agreement.
But there's no date certain. That could be, you're right.
You
I mean,
couldn't possibly have a date certain?
No, but you can have within 30 days of getting a license, within 6 months, that type of thing. We don't have, and that was my point too. And other agreements do, because other agreements had to build casinos and whatever, and they had dates certain that certain things had to be accomplished or they'd face a penalty. So I agree, I'm just saying I agree with you. We don't have that level of specificity in our host agreement at this point in time.
I think, I really just have to say, they want to open up their facility. They cannot open their facility until they provide the fields, or at the town's election, the town takes a check for $3 million. So it's hard, on the one hand, to say we don't want the facility because we're concerned about the impacts, and on the other hand, say they can take as long as they want to build the facility, and we should put a deadline on them to build the facility. You know, I think if we're being honest, we need to recognize that either we support the facility or we don't. I have no view on it one way or another, but my view on those, you know, very convoluted clauses that were, you know, another clause that is in some of these other host community agreements requires insurance for facilities. Well, of course they're going to insure their facilities, and you don't need 5 pages of single-spaced type to require that they do something they're going to do anyway. That is something that private parties do to protect their investment. So I can't conceive of them deciding they want to take longer than they need to take to construct the facility. And were they, for some unknown reason, to do so, I can't understand why the town would object to that. Because yes, they wouldn't have the fields, but they wouldn't have the fields if you rejected outright in the first place.
So the agreement says that they can't operate until the fields are completed.
I will read to you what the agreement says. E&A, that's the applicant, shall fully complete its obligations under this paragraph, that's the paragraph that requires the construction of the fields, including said annual, not including said annual payment, because that's something that happens on an annual basis, prior to seeking a certificate of occupancy for the Equine Center. So they cannot even ask for a certificate of occupancy until they have constructed the fields or at our election paid us $3 million.
Okay.
So you would tend to think they're not going to spend $25 million building a facility, or $50 million if you include all the off-site improvements, and then delay seeking a certificate of occupancy any longer than is necessary. Because once they build the facility, they're going to want people to come to it.
Okay. One last point. Maybe this was covered earlier, but I missed it. I'm still confused on what happens if the agreement says 10 racing days a year, and the state at some point says you must have 60 races a year. What prevails?
So I will be very clear. Unless the town decides it wants to amend the agreement, which is entirely within the purview of the Board of Selectmen. There's a contract that says they cannot race more than 10 days per year. It's clearly a material term. It's its own paragraph in the agreement, its own section in the agreement. They have to comply with the contract.
Okay.
If that means they sacrifice their license from the Gaming Commission, they sacrifice their license from the Gaming Commission. That being said, and Will has worked for just about every racing commission out there, I'm not familiar with any gaming commission any racing commission ever forcing any track to race more days than it asks to race. But I don't know, Will, am I wrong on
You
that?
are correct. I have never experienced that.
That may be, but we never know. The state is looking for money, so they're looking for ways of getting more money, so I could imagine at some point they would say we want more races. But what you're saying is
I'm sorry, but they lose money on racing too. The applicant's going to lose money on racing. The state loses money on racing. More racing, more losses. Nobody wants to have more racing except the people who own the horses.
Why then are they supporting horse racing?
Because they love horse racing. It's a game they enjoy.
The state?
No, the applicants.
No, I think he was talking about the Commonwealth.
You're talking about the state because it has economic impacts. The people who own horses spend millions of dollars caring for those horses. It is the high economic impact form of gaming. Casinos have economic impacts. Lottery mostly provides money just to the state. Horse racing employs hundreds of people, thousands of people in the jurisdictions where it's big, and has impacts on the agricultural sector of the economy that no other gambling enterprise has. That's why most states support their racing industry in one way or another.
And dog racing doesn't do that either.
Correct. That's why dog racing is largely gone.
Okay, just one more point on the number of races. So the agreement says 10, the state says you have to do 60. The applicants decide they're going to do more than 10. What happens?
We immediately go to court. It's not like they're going to just surreptitiously in the dead of night have an 11th race day. We're going to know about it. We go to court. We get an injunction because this is crystal clear. There's no ambiguity. It says 10 race days, no more than 10 race days. We go to court and we recover our attorney's fees and our costs.
Okay, thanks.
Thank you,
It's not
John.
crystal clear. I don't agree. There are
Wait,
material
wait,
breaches of contract, and there are minor
Recognized,
breaches of
please, so we don't
contract.
have this arguing
We have
back
a
and forth.
6:35 public hearing.
Yeah, I know.
That's what I was going to get to, Madam Chair.
Well, that's what I was getting
Yeah,
to
yeah.
also, but a public hearing can start late,
But I was
can't
just
start early.
thinking
But
that-
we are,
Okay.
There's a couple.
we're beyond the, I'm afraid we've had questions from the audience, which we don't normally do.
But you haven't touched upon the residents, and it was brought up about the fact of houses. It was touched upon, and I was.
Wait a minute,
appreciating
that-
bringing that up. There's nothing in that agreement that says they are not using Breakneck Road. They may say that they're not going to. Has the town said that they're not going to?
It's in the host
Concern
agreement.
is my street.
Yes.
But it's not.
Jonathan, can you just answer that quickly, because we do need to move on?
We did
Would you
insert
give
it
your
into the
name?
zoning.
My name is Patricia Scales from 87 Breakneck Road.
Jonathan, go ahead.
I'm just pulling up the provision that addresses it.
We don't have the agreement, so we can't even see.
It's a public document, you'll get
You
it.
can,
It'll be available tomorrow.
it'll be,
After
Put it
today,
online.
it'll be up online.
That's why we're not going to vote on it today, so people can see it.
It's not only in the agreement, but also the zoning bylaw prohibits the equine facility from using Breakneck Road.
Right, what about the town using Breakneck?
So here, can I just quickly read the one paragraph provision?
Yes, please.
That's most relevant. Access to the Equine Center shall be off Cross Street via a new I-84 interchange. E&A shall not, in all caps, permit any vehicles accessing the Equine Center, except emergency vehicles, to utilize Breakneck Road. E&A, at its sole expense, shall employ police details for race and festival days to enforce said restrictions as may be deemed necessary by the town's chief of police.
Okay. Thank you, Jonathan. Okay.
I have a
Okay,
question.
Bob, because I asked you before and you didn't, but
I have a question on the host agreement, on a whole different subject matter.
Thank you, Madam Chair. I just want to, I'm Bob George and Davis. I represent the proponents of the project. I want to talk just a little bit about the negotiations that we went through to get here today. They were not quick, they were not easy. We started with is this on?
yes,
We started with an agreement that did not include revenue from gaming, that did not include the enforcement provisions, that did not include a lot of the things we had here. This agreement is also the product of really a year's worth of hearing what the community had to say, listening to people. Based on what they said, we added things to the agreement. We put in the I-84 interchange. We added little things like exercise facility for seniors. Everywhere we went, if people asked for something, we provided it. This agreement is really a good agreement for the town. It was negotiated, there was a lot of give and take, a lot of give on our part, and I think this agreement is ready for a vote tonight. And I think the town meeting should have this agreement in place before we go to town meeting so that we know what we're talking about. This memorializes and solidifies our promises to the town. 1.5 million, 1.3 million once it's up and running, the ball fields, the community gardens, the farms, the farmer's market, it's all in there. So I would ask the board to vote tonight to approve this community agreement.
I've supported this since day one. There's no way we're going to vote on something that the residents have not seen. It's just not going to happen.
Yeah.
well, we don't need to clap, thank you, no one performed. Mary?
I just have a little bit more, and I am going to make a motion, but in terms of this host agreement, there are a lot of residents who are extremely concerned with the, what I will call horse treatment. I'm not going to get into those that think it's cruel to horses and those that don't. It's a very emotional argument. But we've really, other than saying they'll use best practices, that's not defined anywhere. So the common person picking up this host agreement, myself included, has no idea what best practices means in the horse community, as that term is used in this draft. You need to really spell out what the heck that means. And some, because these are more promises, so, and I know Mr. Fields is extremely proud of himself for introducing legislation that dealt with horse doping and that type of thing when he was the principal owner, and probably still is, of Suffolk Sterling and Suffolk Downs. So the host agreement doesn't address that at all. What happens if jockeys come in and they've doped their horses? And I know he said they're not going to be allowed to race at my facility. All those things are promises to the town. They should be incorporated into this agreement, including a cease and desist operations if we determine that there are horse deaths and euthanasia right on the track, which I'm told happens. It happens more often than we would hope that it happens. They're euthanized right there. A maximum amount of horse deaths per year with these 10 races, and then it's a cease and desist. You know, one horse death is probably enough, but that has not been addressed whatsoever in the document, and it is extremely important to, to residents. Probably not quite as important as limiting it to 10 race days, but it's right up there, and it's nowhere. It's nowhere here. So at this point, I am going to make a motion for a second opinion, and I think we should take a lesson from the applicants. I mean, Mr. Fields is a very sophisticated casino owner, resort developer, racetrack owner, and, you know, he engaged some very good local attorneys that oversaw this part of the host agreement, but I was surprised to read, when I did eventually get by email a copy of the 194-page application, that his attorney, for their attorneys for the application to the Gaming Commission is an attorney we've not met. It's a boutique Boston law firm, and it's a gaming professional. So he chooses different attorneys for different tasks, and I think it's only reasonable that we also get a second opinion on this host agreement and follow suit. And I think, you know, Jonathan should embrace it, because second opinions are always in the best interest, if you can, of clients, particularly when this is on the cutting edge. We have no other document to look at with respect to sports betting, because guess what? We're doing this before it's even legal in Massachusetts. So I'm going to make a motion.
Can I just, before you make a motion, the issue of the maltreatment of horses and penalties, therefore, are in the agreement, second paragraph of the 9th page.
Yeah, does it talk, not in the level of,
Jonathan can...
Yeah, I mean, what we didn't do, which I think is what Mary's
Yeah,
suggesting, is sort of lay out a schedule of of various specific
I saw that.
instances
yeah.
of mistreatment and what the repercussions of that would be.
I-
And we certainly had a great deal of discussion on this topic during the negotiations. I think at the end of the day, it becomes a question of whether the board wants to be making determinations of a very technical nature, and whether the applicant would be willing to accept that. I don't know about the first. I can tell you we had a lot of conversations with them about the second, but that's,
Right.
you know, so.
Yeah, let me just address our town administrator. I began by saying the reference of best-in-trade management practices was not sufficiently clear, and we didn't have a definition of what that meant to the common person. So I referenced this paragraph, so I have read it, and it's not enough. It doesn't deal with doping, and what are the consequences if jockeys come in and do dope, and what are the consequences if deaths do start happening at this track like they do all over. Those are the kind of things that have not been stated, and those were big promises, and I think that it's reasonable, given the length of negotiation on it, that it is set forth in more detail. So I'm going to respectfully make a motion that we request a second opinion of the host agreement that has been presented tonight to another gaming attorney who specializes in gaming, and request the applicant to pay for this consultant, given the fact that we have rushed and we haven't engaged in all due diligence. And that's my motion.
I will second that motion with the caveat that I'm not sure it's quite ripe yet, because I think the first thing that has to happen in this process is this agreement has to go to the community, and we have to get community feedback first, and then probably have that conversation at the next meeting. So I just, because I don't even, I agree with the point Mary's making, but realistically, I think it's just first thing that has to happen is the agreement goes out, feedback comes in, and then we figure it out from there.
Well, I will modify my motion to read that this draft goes out to the community, we accept feedback, but then we still, based on that draft, get a second opinion from a gaming professional, another gaming attorney. I'm not going to be personally satisfied to just get feedback from the public and then come back. And again, I think the applicant should understand, the applicants have a number of attorneys that have, that he is engaged in for different reasons. And I think that this is reasonable. Again, if this is the biggest thing that has happened to Sturbridge, we should make sure that this host agreement is as positive as it possibly can be, and I think a second opinion's in order.
Okay, I'm not going to support that because we pay town council, we have a town administrator, we have a town planner, and there are attorneys for the proponents who I believe have the best interest of the town in mind. And I believe that probably the best course of action would be for the negotiators to take the input from tonight to see if there's anything that we could add to it. And I don't disagree that we could put the draft online tomorrow and get
That was the intent.
feedback.
Yep.
Chase, what do you think?
I agree that these guys are probably the best in their field. And I think they've done a great job. I don't see how a second opinion would hurt the board of the town, so I'll be voting in favor of a second opinion.
Ian?
I thought the process would be more that we would bring them in tonight, let the community have input, and then we would go from there. I just feel the timing is odd. I would expect that more like at the next time we open this up again. But
Right, I think, we're delaying it, trying to get another opinion on it. As I say, I have full faith in the negotiators we have. Okay, so we have a motion, we had second, we had discussion. All in favor of the motion? 3, all opposed? 2. Motion passes.
I have a question for our town council, and Jeff for that matter. So we've been given a copy of that application for the horse license. When can we expect to get a hard copy of that? We were told we would, but I haven't seen it yet. And I'm not, it's a lot for us to use as volunteers, 200 pages of my own copy paper. And while I'm saying it, I will state for the record, I'm extremely, extremely disappointed, and I was somewhat shocked that after the public hearing, during the public hearing at the Public House, I said, will we have an opportunity to review the application before it's filed? I mean, we've gone out of our way to have special meetings. The Public House public hearing was a special meeting available. I went to the informational meeting, and I was assured that, yes, we would. And we did not see it until after it was signed several days later. And we did not see our chair's letter written a couple of days after that until 3 weeks later. And I consider that a real ethical problem, because town administrator said town council has reviewed this. And it's in an email, town council has reviewed this, and we got it after the fact. And this board represents the town of Sturbridge. We're elected by the people, and I consider that promise number one broken. Broken by, and not as much the applicants, because when we're represented by council, I mean, technically, it's not an ethical violation if they supply a copy of the application in advance, but I was assured that we were going to get it, and we did not. And when we're the client, and that was the application which stated the 10 days and everything else, we learned about the other attorney in that application. There was a letter that I wrote to the Gaming Commission after, co-authored by Selectman Goodwin, which made it sound very vague, again, and ambiguous with respect to who supported it. And that was given to us after it was filed. And, you know, it's been a while since I practiced law, but when a client asks to be sent a copy, and they are not sent a copy until after it's been filed, that's a real ethical oversight.
Could I please respond if
Yes,
my
please.
ethics are being questioned?
Please.
I did not receive, first of all, I don't remember the conversation you're referring to.
It was during the public hearing, and you're more than welcome to
No,
watch.
I'm not saying it didn't happen, but let me tell you what did happen. I did not receive a copy of the application before it went out. We had a Zoom conference with the applicant during which the applicant reviewed certain sections of the application that were relevant to the town. Mr. Cummings was on the call, and the town administrator was on the call, and we saw those certain provisions. The applicant didn't want to provide a copy of the agreement, lest it become, of the application, lest it become a public record. Had I had in my mind, had I known or been conscious of the fact that the board wanted to review copies, a draft of the agreement before it was filed, and it was a long meeting, I must have just missed that. I'm not saying it didn't happen. I'm sure you remember it correctly. Had I had it in my mind that reviewing their application to the Gaming Commission was something that the members of the board wanted to do before it went in, I would have said that to the board. I don't control the application. I didn't have a copy of it in my possession, and I never did until you did. I also never had in my possession a copy of the letter that you referred to, and I certainly didn't draft it until it was filed with the Gaming Commission. So,
You mean you didn't
if my ethics
read
are
it?
going to be
You mean-
questioned,
I think you said draft it, you meant
Parliamentary.
read it. No, it was just,
He didn't draft it.
I didn't draft, I
No,
think
no,
the
no,
suggestion
yeah.
was I drafted a misleading letter,
The last
and I want to be really clear, that did not happen.
Did you review it before it was
No.
filed?
Jonathan, I wasn't giving you a hard time. I said, you used the word draft when you meant to say read. That's all I was saying.
Fair enough.
Uh,
Sorry if, well,
Not,
I'm not used to my ethics being questioned by clients in public settings, so.
yes, I understand that.
Well, it is a real lack of, a real breakdown of communication. Our email from our town administrator said town council has reviewed the application.
That's what I meant, the Zoom meeting, we
Well-
went over.
Jeff,
And-
town meeting,
can we
well,
move
no,
on?
it's-
No,
That's fine.
that's fine. What you believe and what we did may be two different things.
what you wrote to us, you said
did-
he
he
has
did-
reviewed the application.
That's what I meant. We went over it on the Zoom call, all the relevant sections that were relevant to the town before it was filed. If that, to him, doesn't mean we reviewed the application, then that's my fault. My opinion, it was reviewed before it was submitted by town council on that Zoom call.
The review.
All I meant was I didn't have a copy
That's fine.
that I could have forwarded to the members of the board.
Right, he didn't read
And
the
failed to
hard
do.
copy.
Well, I'm glad public hearings are put on local access, because we were assured, and the representatives are here, will we get a copy? And you said yes, and we didn't.
And the applicant has promised hard copies for each and every board member.
Okay. Okay, so So we need to move on.
And what's the, just so I'm clear, what is the process the board would like to use to select their alternate attorney?
Well, we would have to get a list of attorneys that would qualify, pricing included. So that'll take a while. And then it would be up to the board to make a decision on which one to use.
Okay? All right. There we go.
Okay?
Yeah, we'll make a
Okay.
list.
Next on the agenda, we have a posted public hearing.
So we should let everybody leave.
I got it. Yeah,
Yeah, I know.
all right.
I sort of zoned off my. It's been a long day already, Mary.
Okay, do we have anyone here representing National Grid?
Thank you.
Would you please come down? Okay. Mr. Miller, could you take your discussion outside, please?
I'm sorry.
Okay, you can sit at the table. Okay, state your name.
Connor Reynolds?
Okay.
What's your name?
Connor Reynolds.
Connor.
Okay, for the folks at home, would you just give a synopsis of the poll you want to move and why?
Give me 1 second to pull up this.
Good evening, Tom.
Good evening. So while he's looking that up, Tom Chamberlain representing the Trail Committee. This is a part of the Federal Grand Trunk Trail Project from the Ed Calca Bridge out to the intersection of Kelly and River Roads. And in the design process, we were looking at a couple ways of how we can get the trail safely along the shoulder of that approximate 200-foot section of Farquhar Road. And in that, we looked at several ways of building the shared use path, and we were limited as to that section of Farquhar Road is a raised roadbed because of the flood storage area needed for the Westville Lake project. So in designing the path of 5 to 6 feet wide, there is a pole, and the number escapes me, but
24.
24, thank you. There is a pole that we needed to get relocated to allow for the width of the shared use path. So in contacting National Grid, they came out and looked at the situation and came up with two options. One is to relocate one pole, pole 24, to the other side of the street, basically right to the other side of the street. That pole location would require what's known as a kicker pole, which is a pole in the back that angles down into the ground to support it because of the curve, the radius of the curve and the turn. That kicker pole, we've obtained an easement from the abutter to allow that kicker pole to be placed. And so that's the hearing that you hear tonight. The other option to avoid the kicker pole was the actual placement of two poles to, you know, kind of break the corner, not as severe.
Mitigate
And
the angle.
Mitigate the angle, thank you. And in review of that, we thought just changing that one pole to the other side of the street was the best way to go. So that's why we're here for the poll hearing tonight, is to move that one pole on the other side of the street.
Okay, questions from the board? Okay, it's a public hearing.
Did you want to read the public hearing notice, please?
You want me to go?
Oh, I thought you read it.
No, no.
Pulling to himself. He did read it.
Trying to make up for lost time here,
Yeah.
Case.
Town of Sturbridge Board of Selectmen public hearing. National Grid has made a petition of the Sturbridge Board of Selectmen to relocate one pole on Farquhar Road beginning at a point approximately 315 feet east of the center line of the intersection of Farquhar Road and continuing approximately 30 feet in a north direction. National Grid also requests to relocate pole 24 to the opposite side of Farquhar Road to accommodate the Grand Trunk Trail project and permission to lay and maintain underground laterals, cables, and wires in the above or intersection public ways. The poll hearing will take place on Monday, October 18th, 2021, at 6:35 PM at the Sturbridge Town Hall, second floor, Veterans Memorial Hall, located at 308 Main Street, Sturbridge, Mass. 01566.
Okay, does the board still not have any questions? Okay, any questions or comments from the public? Okay, is there a motion to close the public hearing?
I move to close the public hearing.
Is there a second?
I'll second that.
Discussion? All in favor? Okay, 5-0. Okay, someone willing to make a motion?
Yes, I will move to, move the pole, or poles, I should say, I guess, on Farquhar Road as laid out in the memorandum provided here tonight and as explained by Mr. Chamberlain.
Okay, is there a second?
I'll second James' motion.
Discussion? All in favor? Okay, we're all set?
Thanks, guys.
Who seconded that? I'm sorry.
Yeah.
I did.
Yeah, thank you.
Can we call Alex over to see if we can get her for tonight? I know she's right there.
I can imagine what she'd say. Okay. Okay, next we have department reports. Building Department, Nelson.
Thanks, Tom.
Good evening.
Good evening, Nelson Burlingame, the building inspector in town. First, I just want to say I'm glad to be back in Sturbridge. I've been gone for a bit, and, you know, we had some personal health reasons that I was gone, and it's really nice to be back in town. What I did is, because I haven't been here for a while to these meetings, I included the months of June, July, August, September, and if it's okay with the chairman, I did list out the electrical permits, the permits and everything, but I mean, everybody can read them, they're on the paper.
All right.
Okay? I'd rather just to get to what is actually happening in town, to keep everybody informed. What I did is I broke it down to ongoing commercial projects, and I listed them out. I'll go through them. The first one I listed was Days Inn. It's on Route 15. It's over in back of the Pilot truck stop. What they're doing is they're upgrading the inside of the building. They're bringing it more up to code. Through the years, they had made some changes in the building, and some of them were never documented, so we're catching up on it, and we're making it a safer building. The next one is 9 Holland Road. We ordered the building to be boarded up. The owner hasn't done it yet. We're in discussions with him. He has cleaned it up some. We are coming up with some solutions as to what he can and can't do and what he should do, but again, it's making the building safer. What happens in that building is, through the years, I think everybody has noticed, it gets boarded up, and then the boarding seems to get old, and people, or kids, I should say, probably break in, and then you have to go back and revisit it and board it up again, so we're on the upswing on boarding that up. And then the two larger projects in town would be 6 Picker Road and 90 Charlton Road, the cold storage buildings. 6 Picker Road, they've got just about a lot of the site work done. I won't say all of it. They've got the bridge crossing over the wetlands. They've poured the foundation and the floors. They're hoping to get the steel up in the next few weeks and closed in before winter. They had a big retaining wall they had to put up in blasting. They did that. The next project is 90 Charlton Road, cold storage. They're still actually blasting down there, and anybody that's been over there and seen the site, it's quite a hole there. So they've got a lot of fill, they've got a lot of blasting. They haven't really started the building yet, but I know they're anxious to. And then 69 Hall Road, it's a new 8 treatment room for a dental office. They're doing inside the building over. Rapscallion. I know a lot of people have asked about that and why it's not open. The biggest thing, as far as I know, and Jeff can add to it if he wants, I know as far as the licensing, they're waiting for the food source. And at one time, they were going to have a catering truck, then they weren't. So it's been up in the air. And to issue a license, they need food to go along with it. But as far as the building end, it's been inspected. All the life safety items have been inspected. And as far as the building department, they're okay to open as soon as they work out the rest of the details. 198 Charlton Road, they're working on a fit-up on the first floor. It's an insurance brokerage house. It's like roughly 3,500 square feet. 40 Main, which is Edwards Gas. Anybody that's gone by there recently, you would see that they're remodeling it. They're doing a new outside facade. They're redoing the inside with a convenience store. They're working on it right now, and they've got quite a bit done. The other project, number 9, is Cornerstone Bank. Again, if you've been by there, you see the new facade. They reconfigured the inside to make it more user-friendly. They have had some things they have to correct, because I went there to do a final maybe a week and a half ago. And not big things, little things. An example is their rear doorway. When you walked in, somebody had built, and it was a beautiful rail, it was metal, but they made it too long, and for whatever reason, they didn't cut it, and they had to, because it actually came out in the door. And then there was some talks about the ramps. I had some questions about that, and the accessibility route, and I think that's worked out too. So I'm hoping to sign the final on that soon. Then the 10th project I got down is the old Jimmy D's. They want to open another deli there. They want to take the downstairs, when I say downstairs, the cellar, and they want to move their dishwasher and stuff like that down there. But they've had a couple of things they have to deal with there, a couple of problems, but I don't really want to mention them. And then I listed it out as done commercial work. I don't know if, probably most of you do know, the Stave Lost Theater in back of the church, or in back of the, you know where the little tuxedo building is, the round one? Right in the back there, they changed that now, it's a church, and the church has actually opened up, and Stage Loft has actually moved out, and, you know, I think it was because of the virus and everything, and it just was too much. The Granite Group, which is the old Paletti's, it's a commercial plumbing supply house. You have to be a licensed plumber or whatever to actually buy there, but they're opening, or they have opened. They're doing a great business. I think it was something that we needed in the area, because you can't, you know, there's nothing around as far as that goes, so I think that was a great addition to the town. The charter school, the Sturbridge Charter School, they added the 7th grade. They're doing it in that white building, White Tavern, I should say. And it's again, it's for the extra class. They're hoping to eventually, very soon, start a new school, maybe next year, as far as adding on, because eventually I believe they want to go to the 12th grade. They add a grade every year. And then anybody that's been in the Dunkin' Donuts at 120 Main, they did a remodel on the inside. They made it look more, you know, modern. It looks really nice, and they made some changes there.
Because even on the outside too, where you put your order in is different now.
Yes. They put a sign up, and
Well, I almost missed it.
yeah, they changed.
I drove right by it, good thing there were 4 cars in front of me.
Yeah, they tell me everything's for the better.
I could have heard a voice, I heard a voice, and I found
Yeah.
it.
Upcoming commercial projects, the Rico's Market, which is next to the pot place. There's going to be a deli there, because that building, half of it was empty, and they're supposed to be coming there. I haven't issued a permit yet. I had some questions on their whether they're going to do a 34 review or call it new construction, I'm not sure. They call it a 34 review, which is fine by me. But in some ways, I told them it could be a new construction, it might be easier. They haven't sent back the paperwork to me yet, so depending on what they do, but we're working, building department's working closely with them. 380 Main Street, Wicked Licks, that's where the old travel center was. The village sold it, and a lady wants to open an ice cream shop there.
Yeah, what's the holdup on that? Because,
Right now, I actually talked to an engineer today about it. They're doing a 34 review on that too, because there's a change of use. And I'm waiting for it to come back. And actually, the person was doing the 34 review for there, plus the old Jimmy D's, so she's doing a review on actually both buildings, the same lady. And she's supposed to meet me actually tomorrow night, because it's easy for her to meet in the evening, so.
yeah, because she got her permit in spring from the planning board.
Yes,
And it-
yes. She has never actually came back, she's never actually made her own application yet.
Yeah. She's missing ice cream season.
Yeah, I would be, yeah. 178 Main, the old J.C. Penney's space, that just recently went to planning too, and they gave them some variances, and they're gonna divide that space into 3 areas. Planet Fitness, I know, is one of them that's gonna go there. The other 2, I'm not sure if they're even sure themselves quite yet. Noble Energy, that road was accepted there where that address is. Or actually, I'm a little confused. I take that back. Noble Energy, the old Ford truck stop, they're gonna start up and start working pretty soon too again. 150, right, almost across the street, interstate towing that's in there now. They're hoping to open a new towing company building there, next to Cornerstone Bank. They've asked a lot about it. Again, they haven't submitted their plans yet, but I believe they will very soon. Of course, the old Friendlies, there's going to be a burger restaurant open up that was bought by Teddy G's. The 7th thing is that 55-plus manufacturing housing community, which is located at 30 Main and 20 Fisk Hill, which it will kind of loop around, just to give you an idea where Eddie's Garage is. It's that location there. They're planning on 71 combination single and double wide trailers. Matt Sosick, he owned the land, and he just got the okay from planning on a subdivision road, and they needed that to actually do the trailer park. And now that that's there, they're moving forward with that. They actually have had a design for maybe a year and a half or so that went through planning. And Gene said that they are going to tweak it a little bit, but it isn't much. It shows the roads, the lots, and everything. The 8th thing is 308 Main, Deep Roots, that whiskey distillery, the Mill Yard Marketplace. When you're looking at the building itself, it's going to be right at street level on the right-hand side. I think that's going to be pretty neat, too. They're going to make their own whiskey. I think they're in the audience now, the people that own it, I think. So they probably could tell you more about that. And I think I covered most of the things that are either coming up, closed, or we're working on. If there's any questions?
Any questions from the board? Mary?
Well, just want to say welcome back, Nelson.
Thank you.
I haven't seen you really since you've been back. That means you must be very busy, or I'm not in center office building enough.
No, it's busy, but that's a good thing.
It is a good thing.
Yes.
I was trying to find if it was here, and I don't know what, it might be, so I apologize if it is. The gas station / liquor store / convenience store next door
Yes,
to Dunkin'
120 Main, Lucky Mart, yes.
Oh,
I don't,
Lucky
yeah,
Mart.
I should have put it on there. I might have
Used
missed
to be
it.
an Extra Mart.
Yes.
So, give us an update on that, and then I also want to ask, they've got all their liquor posters hanging. Now, I haven't looked in the last couple of weeks, but they had all their liquor things
Yes.
taking up most of their front windows, and I thought that
Yes.
was a issue with our bylaw.
It is. What happened is, there's been some delays on that, and they're trying to survive, I guess, like you'd say, everybody else.
Right.
They took their pumps down. I think they thought the new ones would be up a lot quicker. They're not. They're finally getting to a point where they're pouring their footings and stuff for the island, for the gas island, because, they need that up to get people in the store.
Right.
They've got a small addition to the right and one to the left. They've just poured the footings the other day for that. I agree, there's signs up there. I seen them. I shouldn't say I ignored it, but I feel bad for them that, their business is hurting as it is. I mean, if I'm directed tonight to go and have them take their signs down, I will. I think they're just trying to advertise to get people coming in, especially with the fence up and everything. So I guess I'm looking for direction, and if you,
Well, I think it's just a matter of time before other liquor,
Yeah.
because they've turned largely
Okay.
to a liquor store. They made that metamorphosis. When it was an Extra Mart, it was very different. And then this board gave the extra license.
Okay.
And it's going to
Okay.
become a liquor store, and if they're allowed, it's going to be a matter of time before.
you're right.
Yankee Spirit says it and everything else. I do feel badly about their gas, but I'm just going to speak for myself. I think those signs have been up for many months.
Okay.
And I don't really feel it's fair to other Extra Marts.
I will take care of it tomorrow.
I don't know, that's just me. I don't know how the rest of the board
Nelson,
feels.
we've had this discussion for years. The bylaws are the bylaws, voted
Right.
on by the people.
Right.
Not 50% of a window should be covered.
You're right.
And it's happening more and more. And one sees one, everyone does it. So you really have to nip it in the bud. It's
Okay.
my opinion.
I can leave some up. I mean, they don't have to have none. It's-
I understand.
It
long as it
looks like an
doesn't cover-
urban, it looks like we have no sign bylaw. When you drive by there.
Yeah, they behave for a while, and you really make them behave, and then it kind of gets carried away,
Yeah, but
and
you
you got to
have
bring
to-
it back to center, and, you're right.
The same with the signs that people tack on poles,
Yeah, yeah.
and they never take them down, leave them up.
I will admit, I usually, a lot of times, I rip a lot of them down lately, probably not as much, because I've been busy between the 110s and a lot of these bigger projects. I'm trying to keep moving them along, and it takes a lot of my time, but I'm not making excuses.
Yeah, no, even for the Harvest Fest, I mean, people put signs on the common. The only signs.
Right, right.
People from you, and they have to have something to do with the town.
Right.
No opinions on things. Okay, anything else for Nelson? Okay, welcome back and have a good night.
Thank you. Thank you. Have a good evening.
Okay, next. Which DPW?
Just want to say, to help Nelson out, I generally pull a lot of those signs down. I call Cindy, and if there's no permits,
Good.
we pull them down, especially
No,
the yard sale signs.
That's good. That had come up before about
Yeah.
even the police going by if they're not on a,
So if anybody has signs missing, it's probably me.
I always thought it was Kavinsky during the election.
I can't touch those signs. So you have my August and September reports. I'll just give you a brief update. We really don't have much out of the ordinary going on. All we have is, we finished the milling, we finished the paving. Blueberry Lane was a full reconstruct, that's all set. We're busy now backing up the berms with loom. We added a lot of berms to help the drainage. And that's about it, and now we painted lines last night, if you didn't notice that. And then we're into snow and ice, so we have 4 trucks ready. We have half a shed of salt. We're looking for some salt sign-offs on you tonight, and we'll fill up the sheds, and unfortunately, we're ready for winter.
okay, speaking of winter, our winter parking ban goes into effect, is it?
November 1st? I
First.
think so, yeah.
And that's our next meeting, so we probably ought to put it up on the,
Yeah, I can put it up on the community
Yeah.
page.
but it's not going to snow, but
fall. No, I know, just hearing the winter parking ban, gee.
I know some towns have already put it in.
Yeah.
So,
Okay, any questions? Which I had one question on page 66, under Parks and Rec, said started working on Sunshade Project. What's that?
oh, the Sunshade Project is, the rec department bought a sunshade system for the softball fields down behind the town barn, and they asked us if we would install it, and we said, sure, no problem. Well, there was a problem. So we had a professional come down and evaluate it, and then we've since got a transfer from the Finance Committee to have a professional come down and install that for the rec
Good. I
department.
mean, they need it down there. They've needed it for,
Yeah, no, they'll have
20
one,
years.
they'll have one on each side. It's similar to what they have at the Burgess Little League field at Burgess. It's that fabric. I got a couple more things, but I think you got a couple in between.
yeah, we're moving quickly. Okay. Jeff?
Yeah, in the packet this evening, there's just one comment on my report, had to do with redistricting. When it is adopted, I think this week, we will no longer be represented by Senator Ann Goby, but by Senator
Fatman.
Fatley. Yes. Also, on the dais this evening, there's an additional agenda item packet that I'd ask you to consider under new business. There's just a couple of things. Also on the dais this evening is a report on the free cash as certified by the state of Massachusetts, with some explanation from the finance department on how that number was arrived at. We have a free cash certification of 6.2 million. Last year, we had very unexpected additional revenue of over $1 million. We had a couple of unique things that happened, and then the total general fund budget was underspent by about $1 million. So those two numbers combined added to the increase in the free cash. So that's on the dais as well.
Did you want to discuss that now, or
Discuss what?
free cash
It's just for your
information? Well, I just have a comment on that, and I've made it in past years, that our free cash is constantly growing, and maybe we ought to look a little bit more tightly at our town budget. I know at one time Barbara, because she had been requested to, gave us a breakout of all the departments and the monies unspent. So
I'm working with finance on a monthly report, revenues and expenditures, percent budget expended, and some trend analysis, so hopefully we can implement that this fiscal year. That leads to those resolutions you're talking about.
yeah, but also if we could get for last fiscal year, the money returned to the town.
I think that's in the report.
Oh, I didn't get a chance to.
Yeah, the underspend of the general fund budget was about $1 million.
Yeah, but breakout by department.
I think it's in here.
I think it's on the last page.
It's on the last page.
It says expenditures at the top.
Yep.
Jeff, with that,
Okay.
with that, these last 2 years, I assume would be kind of odd years to pick. But from a budgetary perspective, because I'm assuming some of the groups have more free cash around because of COVID.
Well, they shouldn't have free cash.
No,
Well,
I just meant
yeah.
that certain functions you're not undertaking, I would assume.
Oh, no, but every year is different, but this year with COVID,
Yeah.
money is
And
spent.
Burgess had a number in there that was over $300,000 of that million. We had departments that didn't take vacation because there was nowhere to go, so you had a lot of leftover, not a lot, but you had more payroll left over than you ordinarily have because you're not backfilling positions
Yep.
to cover vacations, those kind of things. And most of it, you're right, it would be COVID-related. In a normal year, you wouldn't see some of that.
Okay, thanks.
But again,
nice.
getting into more trend analysis and those reports would be helpful.
Well, that makes a lot of sense.
Yeah. I do know it didn't go too far last couple of times it was brought up.
We have a tremendously powerful financial software package called Munis. The unfortunate thing about Munis, it doesn't produce very legible reports. So developing a monthly report you want to use and can interpret, and then getting Munis, which it can do, to export into Excel, that's kind of the trick. So that's what we're working on.
Okay, thank you. Okay, next we have consideration of possible action on change of officer directors, LLC managers on the liquor license for pizzeria. Oh no. Seems we do this about every 6 months.
Way too often.
Do we have anybody
Yeah.
here from?
Anita Dempsey's on the go-to meeting, so she can answer any questions.
I am. Can you hear me?
Yes. Can't see you, but we
Okay.
can hear you. Welcome.
Thank you, and thank you for allowing me to visit you via Zoom.
Okay, do you
But
want to
yes,
just give a brief overview?
It's been way too often, even for my liking, after 15 years of working with them. Having to submit the paperwork is painstaking. Anyway, moving on.
Ms. Dempsey, you want to kind of tell us what you're asking, please?
Well, so pre-COVID, on the brinks of pre-COVID, they fired the CEO, Jim Alaria. We went through trying to reorganize, and the CFO was ultimately appointed to be the CEO. Our secretary, George Hers, has always remained constant. If you've noticed, he's been the only person on the application. He's our general counsel, secretary, and chief administrating officer. The change is moving Eric to CEO and president, and adding Brad Boston, who's been with our company for 30 years as the DVP. Our bylaws require 3 officers be appointed, and so to that end, we have to abide by the bylaws and additionally, support the liquor license accordingly. So, since we are open and actively doing business, we had done, we tried to do multi-change, which, you passed our manager. That was approved, you forwarded it and went through the ABCC, and because of us unable to get the certificates of good standing that we needed in a timely manner, we had to file separately. So apologies for that. But to that end, it's really a mere formality because the ownership hasn't changed, the company hasn't changed, and it's just a matter of bylaws, and we filed with the Secretary of State and submitting the paperwork accordingly to acknowledge the appointment. End of story.
Okay, thank you. Any questions from the board? Okay, somebody want to make a motion then? I think there is one. You can make it from. Yeah, but I don't think it's on there. You can make it just from the thing.
Yeah, I'll just do it for this. I will move to amend the change of officers, directors, LLC managers for the liquor license of Uno's Restaurants, LLC.
As presented.
As presented.
Is there a second?
I'll second that.
Discussion? All in favor? Okay, you're all set.
Have a good evening.
Yes, you too. Thank you.
All right.
Okay, next on the agenda, we have Consideration and possible action on a farmer's pouring permit for Deep Roots Distillery, USA. Good evening.
Hello. Been sitting too long.
They go up and down if you can find the right knob. Kay, could you please introduce yourselves?
Yes, my name is Erica,
I'm Keith. I'm Tom.
and we are the owners of Deep Roots Distillery, USA. I'll just give you a little background. We're looking for our farmer's pours permit, as you know, but just to give you a little background on what we do, since distilling is obviously brand new to the town, and I'm sure you've never dealt with it before. We are looking to be a craft distillery offering small batch craft spirits made locally with all U.S. source products. We do not use dyes or fillers or artificial flavors, so everything we do is considered natural. The distillery will be partnering with other local businesses for produce that are used in our unique flavoring process. Our plan is to highlight local and support as many small businesses as we can. We will have a manufacturing side that will highlight our process and be toured by our customers by appointment. There will also be the opportunity for a customer to taste small samples, take part in our seasonal cocktail menu that uses our spirits, have a non-alcoholic beverage if they choose, and a small bite to eat as well. So that will be on the other side. We'll have a tasting side. That's where the pour permit comes in. We plan to offer logo items for sale on the tasting room side, and this way customers can take home their own piece of the distillery. Deep Roots Distillery USA is all about giving customers an experience. We do not want to be in a bar. We want to give the customers an experience. We want to walk our customers through the process, including the hows and whys, while showing the local spin on our flavors. So far, we have already received our federal TTB license. We have our FDA registration in place. We have approval for signage from the town. We've gone to the planning board and received our waiver of site plan. We have our Massachusetts alcohol seller server course completed. We've already submitted for our farmer's distiller's license, and we realized that we need that in place before we can get our pours permit, but we were hoping to get an approval contingent on getting our Massachusetts license. It's in review right now. We're told it's about a 4 to 6 week process. It's been there about 2 weeks. We have also already submitted our permits for, our applications for permits for the health department. Our Chapter 34 is in review, as well as Nelson mentioned, for the mill building. And we've also given samples to the DPW for our wastewater for a discharge permit.
Okay, questions from the board?
No, I don't think so. I guess, Jeff, I have a question for you. Is there any issue giving a license contingent on?
No, we've done that before. However, if this is a new license, Jeff, don't we need a public hearing?
That's not my understanding. But we can, this is it's not a kind of a liquor license, it's a pouring permit.
Yeah, it's a pouring permit for whiskey, but it's a new license. It's confusing because we've never had one of these before.
Our understanding from planning was that we didn't need a public hearing because we got a waiver of site plan, but I'm not sure if that has anything to do.
No, they have nothing to do
coincide.
with
Okay.
You can approve it, and if you do need a public hearing, I can bring it back.
Right.
Contingent upon finding out if there's a public hearing request.
Okay, it's just on the old chart, any new license needs public hearing.
This being a farm license, would it fall under a different category than the other liquor licenses that we issue?
No. As a matter of fact, that's what we give most of pouring licenses.
This is, okay.
Yeah, this is a pouring license. Correct. You're not doing the sample.
The farm series makes it a little different,
It's a
because they're
farmer's
going to have to
story.
produce, every single thing that
Oh,
they
yes.
serve is going to have to be produced in-house.
Oh, yes.
So, yeah.
Yes, we're producing everything in-house. It has to be
Yes.
produced on-site. Yes.
Okay, and I noticed on the application, though, you do say hours of operation, Thursday to Sunday, 12 to 9 p.m. And then it's difficult to read the rest of it.
That's for just patrons to come in. So we would be distilling other times.
Oh, yeah, no, that's what I'm getting to, patrons. Do you have your application there? 'Cause
I do.
I love that everything's all natural and nothing artificial and.
Yeah, it's very cool.
Yeah.
Oh, at the bottom, it says Monday to Sunday for production. Unsure of our hours yet, but it would be just for production.
Oh, okay. But the line above it, 12 to 9,
I think it says Sunday.
Sundays closed earlier. Our hours, I believe, that we came up with the planning board was 4 to 9, Thursday, Friday, Saturday, Sunday would be 12 to 9, and Sunday would be 12 to 5, I believe.
yeah. I mean, you can put them all under 12 to 9 and close early, it doesn't matter. It's just that if it says 12 to 4, you'd have to close at 4.
Oh, yeah, we would, most likely Sundays would be closed early. Nobody wants to
Yeah.
come at 9 o'clock at night. We don't want to be there at 9 o'clock at night.
Well, no one stays home watching the Patriots either. Okay, any other questions from the board? Somebody want to make a motion?
So this is contingent on,
Whether or not there's a public hearing requirement.
and there was one other.
And their approval from the state. The state's actually the one that approves the farmer's license.
And all other. I move to approve the farmer's pouring permit for Deep Roots Distillery, USA, contingent upon any necessary public hearing or any other necessary permits has drafted in the application before us.
Okay, is there a second?
I'll second that.
Okay, any discussion? All in favor? Okay, 5 to nothing.
Thank you very much.
Thank you, good luck.
Thank you.
Great.
That was exciting.
Okay, next we have consideration and possible action on salt bids. I know what happened to my list. I didn't yell at anybody.
Have a little water.
I have water, but
As you can see, we've, as everything else in the world, salt's gone way up. We're up $15.70 a ton for road salt and $14.68 more for the treated salt. So, but these are the low prices. It's lower than what you can get on the state bid, so it's a good price considering it is what it is.
any questions from the board? Someone want to make a motion?
Well, this is also the plowing part too, or is it separate?
No, this is separate.
Yeah, it's separate.
So this would be,
Oh, I see, I'm sorry.
Yeah, that's okay.
make a motion to accept the salt bids for winter 2021, 2022?
Okay, is there a second?
I'll second.
Discussion? All in favor? Okay, now the rates for snow plowing.
Yes, next one is the snow plows. In the past, Sturbridge has put snow plowing out to bid. We only have 9 people that plow. There's more than 9 plows, but there's 9 people that bid. They bid the same every year. And the reason I'm kind of concerned is they could almost get together and put anything they want in these bids. Most towns set the prices so that you know exactly what you're going to have every year. And also, if everybody's getting the same, then I'm free to call in anybody I want, because usually a lot of these people plow the same routes every year. So if some guy comes in and bids lower than the guy that I like to use, then I've got to use him. So now I'm training somebody. And last year we had a couple of new guys, and it wasn't good. In fact, we had guys last year that never been in a plow before. So I'm trying to avoid that. I'm trying to keep the guys that we usually have. So we averaged out what their bids were, and actually these numbers are what most of them bid, and a couple of them were a little bit lower. And then we checked with a bunch of other towns, so we're in the middle. So I'd like to set these rates as the permanent rates, and instead of having a bidding process, we'll just have an application process where they can just apply, give us their insurance requirements, and then we'll put them on a list.
Okay, saves you coming in every year, too.
Well,
For a while.
I'll always be coming in for something.
Okay, any
So
questions?
now, as long as they fall within that rate. We set the rate, and then they...
Right, they either take this rate or they
not.
don't do it.
And then you can take the ones that have already established.
Yeah, then I can keep the
goodwill.
guys on the same routes that we've always had.
That makes
And then if there's somebody new, we'll have to train them. But most of these guys, I've been here almost 3 years, and actually more than 3 years, and I always get the same guys, so, which is good.
Okay, anything else from the board?
Would just is this a total fixed cost, or is it set per, is there any, it's just like $80 for a 3/4 ton for the morning?
That's
or-
per hour.
That's per hour for the truck, the operator, fuel, he has to pay for his fuel, repairs, everything, that's
what I
everything.
figured, but it just
Soup to
wasn't
nuts.
paid. So, that was my only question.
Okay, someone willing to make a motion?
I'll make a motion to set the rates for snowplow contractors as laid out in the memo.
Is there a second?
I'll second that.
Discussion? All in favor?
Next, we have Andrew McDermott. 3 of you, I think, were on the board when Andrew was hired. Mary probably had him in school.
No, I didn't.
I thought that was a prerequisite to work for the town.
One of the few in town. Hey, don't laugh, Jamie.
Yeah, no, they're the best. The students are the best in town.
I'll go back and change your marks.
Anyway, Andrew is a heavy equipment operator now. He's been with us for 3 years. He's actually one of the only one of 2 or 3 people that can drive a standard transmission truck nowadays, because everything we have is automatic except 2 Road Rangers that we have, and he's probably one of the better drivers of that. He also has all his licenses, and he's working on getting a couple extra ones that we'd like him to get. But I'd like to put him in the heavy equipment operator that was vacated by, Tyler when he left to go to the state.
Okay, questions of which or? No questions of Andrew either? Okay, someone want to make a motion?
Sure, I will move to confirm the appointment of Andrew McDermott as a heavy equipment operator effective 10/19/2021 with an hourly rate of $26.91.
Is there a second?
Second.
Any discussion? All in favor?
It's starting tomorrow?
Yep.
Effective 10/19. He's down there anyways,
I
right?
saw you guys the other day, you trusted me to drive you around, so it's pretty good.
Okay, congratulations.
Congratulations.
I got one more.
Sitting in traffic.
And the last one is, we had a stranger, I don't know who he was, he came into the DPW, he had New York plates, and he was congratulating us for a great job on the roads, and he gave us a $50 gift card to Dunkin' Donuts, and it's over the $49.99
Yeah.
limit I can accept, so I wanted to go through the board. Wanted to go through the board and make sure we are on the up and up.
Difference. We don't
Did you,
want to read
did you
about
almost
doing
fall down,
anything.
Butch, when somebody said the roads were in great shape?
No, I hear that all the time.
Yeah, okay.
No, it was good to hear. I wish I could have known who he was, but with the New York plate nowadays, he could have been just a company car from,
Yes.
I don't know who he was, so, but anyway.
Very nice thing to do.
Yeah,
actually.
it was nice, it was very nice, and we always enjoy having a compliment here and there.
Okay, somebody want to make a motion?
Make a motion to accept the donation and authorize the use thereof with thanks.
Second.
Discussion? All in favor?
Very good, thank you.
Donuts for everybody tomorrow?
Absolutely.
Thanks, Butch.
Somebody will say they want Starbucks.
We don't have one in town.
No, I know. Okay, what did I? Okay, I just, what can I lose the agenda? Okay, next we have consideration and possible action on the confirmation of appointment of Michelle Garnon as the Executive Secretary to the Board of Selectmen and Town Administrator. Jeff?
Thank you, Madam Chair. Michelle Garman applied for the position. She was interviewed with myself and Jeed Muban with other candidates, and we found her to be the most applicable to what we were looking for, and we offered the petition, and she has accepted, and we're requesting that you approve the appointment contingent on pre-employment requirements.
Okay, any questions? Do you have any questions? No. We're easy to get along with.
I've been watching on YouTube.
Most times, let me put it that way.
We don't have a start date yet, it's all,
I finished, I did most of the stuff today.
okay, good.
Finished it today.
Okay, someone want to make a motion?
I'll make a motion to confirm the appointment of Michelle Garman as the Executive Secretary for the Board of Selectmen and Town Administrator at a starting salary of $20.85 per hour, conditions of completion of pre-appointment requirements.
I will second that.
Okay, any discussion? All in favor?
Since we didn't
Congratulations.
hear your way tonight, I figure you're going to be really good at it.
You're free to go.
Now,
Tonight, you're free to go tonight. Next time you're here, next time you're here, you have to stay through the whole.
that'll be longer than 10 days.
Thank you.
Thank you.
Thank you.
Welcome aboard.
Okay, next, old business. COVID-19 update, Jeff?
I didn't have anything in particular. There wasn't any new information other than if you've read the news or watched the news, however you get your news, booster shots of various forms are being approved at the FDA level, and we anticipate at some point in our community we'll hold a clinic of either one or many of the different doses, so we're just waiting for information on that from the Board of Health.
Okay, any questions on that? Okay,
Have another COVID-related
Mary?
input. I know that you had said that the different department heads and you are working on presenting something to us in terms of how the pandemic money could be spent. And I'm just wondering, like, I know at one point we thought it was going to come in September. I know we've been busy with other big projects, but do you have a time when we might review that?
We started to prepare the online survey, and with staff changes, that kind of got bogged down, so hopefully by the end of next week, when we can have the online survey up and give a report to the board a month or two thereafter.
Nice, thank you.
Because hasn't there been a few problems with what people thought they could apply for, and now they can't?
I don't know, I think the legislation is fluid in terms of applicability. I think at the end of the day, the federal government wants the money spent in some productive way. I think most communities will be creative enough to do that. We have 2.8 million. We spent some already. Next year, we'll spend a little more. So the basket of funds we have available isn't extravagant, but I think there's enough there to have impact in a couple different areas if we can find the correct mix.
Okay, thank you. Okay, review of the warrant.
Yes, the warrant, as it stands, this is my office's warrant. The Finance Committee has finished working on the special town meeting warrant, and will be providing that to the clerk's office soon. So there's really nothing to do this evening for the board. I just had it on the agenda in case there was. The Finance Committee is making no recommendation on the multi-use field project. They voted 4-4 to place and support, that failed. They voted 4-4 to take no action, that failed, so it'll go into the meeting with no recommendation from FinCom. According to the moderator, anybody can, on the floor, make a substitute motion, or make a motion. Since it won't be a substitute motion, it'll make a motion. So we don't know if anybody will do that, but it's going into town meeting without a recommendation.
Did you check with town council the question I asked you, though, because we placed it?
I did, and what the moderator said is what they arrived at.
Okay, so he talked to council?
Yes, we had council on that round robin email.
Okay, thank you. Okay, new business. Discussion of a joint meeting with us and the remaining members of Burgess School Committee to fulfill a vacancy. When was the cutoff date for letters? Was it the 15th?
It was the 15th. Just back up one second. In the packet, though, were the proposed debt service schedules for both of the projects, so that's in there as well. And FinCom has these as well. The deadline was the 15th of October. So you have the candidates you're going to get. The Burgess School Committee is available to meet with you all on your November 1st meeting. So if you want to set that where you come together and choose or discuss or develop a process whereby you will choose or discuss, perhaps November 1st is the night.
Everyone going to be here then?
Yeah, I was going to say, that's our meeting.
It's our regular.
Yeah, it's your regular meeting.
Yeah.
But they've already said they're available.
It's good. We can have it early on in the agenda.
Okay, so I'll set that with the Burgess School Committee. Would you want the applicants or the candidates there that evening?
Yes, I'm sorry. Yes, we usually do, so we can ask questions and they can respond.
Okay.
Okay, next, Town Clerk. Good evening, Lynn.
So I'm here Good evening.
Good evening.
Lynn Gerard, Town Clerk. So I'm here before you this evening for a recommendation and your approval for a new polling location. As of the last election, we are unable to use the Old Sturbridge Village Oliver Wright Tavern due to the charter school taking over that area. So over the summer, Sheila and I have been out looking at different properties, and we've come across 9 Mashpog Road for the Sturbridge Worship Center. And I have been in contact with Pastor Graham Jones, and he is very receptive to us using the facility there. And I have met with Nelson Burlingame. We did a walk through there, and it seems like a real great place. There's a few little things we need to do. There are some thresholds that need to be accommodation for ADA compliancy, but that's an easy fix with just making a little ramp to go over it, similar to what we've done at Old Sturbridge Village, and striping of some of the parking lot lines for the ADA compliancy. But the lighting is there, it's plenty of room, we've got plenty of outlets, so it looks like a really nice place to have the polling location. So I'm looking for your approval, and then, of course, I have to bring it before the state for their approval, too.
Okay, questions, comments from the board?
Nice job, Lynn. I know you guys were really, worrying about it, and rightly so.
There's not many places in Sturbridge to...
Yeah, and I'm sure, I've never been in that church, but it looks like it's a
it's
big,
big.
open concept.
It's very, very big, yes, yes. But there is not a lot of options. I've reached out to some of the churches, some of the hotels, and it's either a parking issue, or they just don't have the room. ADA compliancy, we even looked at other options at Old Sturbridge Village, too. And, we just didn't have the compliancy for ADA, at least a few bathrooms, and, the parking is a big issue for a lot of the places, as we all know in Sturbridge.
Yeah, not much parking.
Oh, good.
Okay, somebody want to make a motion then?
Make a motion to approve the new location. Do we want to say the address? Yeah. Sturbridge Worship Center, 9 Mashpog Road.
Is there a second?
I'll second that.
Discussion? All in favor? Okay, thank you, Lynn.
Thank you. And then the next item on the agenda. So every 10 years, the state does a re-precincting for the lines, and we were lucky enough this year not to have any issues come before us, but we did review the map. I reviewed it with Jeremy Jalbert, our IT coordinator, and also with Jean Boubon. And basically, it's just a formality for the Board of Selectmen to sign off, saying that they are approving the map as shown, and there's no changes to the current precincting map. Whereas like in the eastern part of the state, a lot of the towns did get some issues with their lines.
Okay, so hold up the map so we can say we saw it.
So basically, it's the same map that we've had for the last 10 years.
That long?
I believe it was 10 years the last time it was done.
Precinct 3?
3? Was it even longer than that? Maybe 15?
No, I thought it was 4 or 5
Yeah,
years.
and we're well below the threshold
Yeah,
of going from 3 to 4 precincts at this time. So that's kind of a good thing right now, especially where, with polling location and whatnot. I don't know if we could do 4 precincts. So in that case, we do need a signed sheet. So you have it? Is
Yeah,
it
or you
signed?
can sign, it's not signed.
Okay.
They didn't vote yet.
I know somebody want to make a motion then to approve the redistricting.
I will move to approve the 2020 precincting map as presented by the town clerk this evening.
Second,
I'll second that.
discussion? All in favor? Now we can sign.
Are we just signing or should we writing our name underneath it?
I had you for math and reading, not writing.
Yeah, not for writing. Not for writing. It's like a baseball player, man.
Oh, I probably shouldn't, can I? Thank you. Red's a little, whoa.
Yeah, I know. But it helps when you're correcting things. Red.
Thank you very much for your time tonight.
Okay, thank you for coming in.
You waited a long time.
I had a registration.
Thank you.
Okay, next. Jeff handed us another bit of new business.
Yeah, there's a small packet with 3 items on it, on the dais this evening.
Yeah, the first one is a request for a waiver of building permit fee to address a crumbling foundation at 12 Woodlawn Drive. Bill, did you want to speak to it? Sure.
Thank you for having me and listening. This is my wife, Kelly. I'm Bill. We live at 12 Woodlawn Drive. And we have a hardship. We're facing a hardship we're hoping you can help us with. We have a crumbling foundation. My house was built in 1985. We bought it in 1999. I can remember standing in the cellar and the inspector saying, yeah, you have some settling cracks. But as the years went by, the cracks increased in size and in number, horizontally, vertically. And I invite you to come and see this. In the past 6 months or so, the past year, this cracking has accelerated. To the point, this past spring, we had a structural engineer come out and do an inspection and write a report. And he said, you need to get this foundation replaced or you need to get it braced. If we were in Connecticut, it would be a Category 3, which is the most severe situation you can have. Replacing a crumbling foundation is a huge financial burden. To help ease this burden, we're asking that the town of Sturbridge waive the permit fees with any work associated with our crumbling foundation. And that's mainly why we're here tonight.
Okay, Bill, did you get in touch with Nelson?
He visited us today
Oh,
and
I
inspected
told him
the
to, 'cause he said
foundation.
he's never seen a crumbling wall.
Yeah, he was pretty impressed with the cracks.
In that good way. Did he give you an estimate on what the fees would be? Because I asked him.
Did he give us an estimate? No. I don't know what they are at this point. Our contractor said they could be upwards of $2,000. I don't know. I don't know the number yet.
Yeah, yeah. He was going to get it for us, but it's beside the point.
Okay.
Questions from the board?
Oh, I'm sorry you guys are going through this.
I do know the board had voted to support the bill that's in the legislature.
Right, and we thank you. Yeah.
And I feel this is really extraordinary. And I do know after the tornado, we waived fees for people who had to reconstruct things. So I personally would be in favor of waiving the fees.
I agree with you, Mary.
I agree too. I'm sorry this happened to you guys. Yeah.
Okay, somebody want to make a motion then?
I'll make a motion to waive the fees at the, is there an address?
Yeah.
What's your-
12 Woodlawn Drive.
12 Woodlawn Road.
I'll second. Oh.
No, go ahead, no, you never do, go
Oh, I
ahead,
know,
no.
I do enough talking, but.
Do it.
Okay, I'll second that.
There you go.
Okay, maybe you ought to add the words, though, what it's for,
For the crumbling.
in case they decide to put
Yeah.
an additional for the crumbling foundation. Okay, any other comments? All in favor?
Thank you.
Do you have
That-
a
that
builder?
helps.
Do you have a builder that's going to give you a reasonable price to
We,
correct it?
yes, we have a person who's going to do the foundation, and we went with the guy that gave us the best deal, the most affordable for us. But there's this other part of, they don't cover the retaining wall that's got to be taken down, or the deck that's got to be ripped up, or the driveway that's got to be torn up, or the finished basement that has to be rebuilt. They don't do any of that, and that's on us, so.
And insurance doesn't cover
No.
any of that.
No insurance and no state reimbursement at this point,
Right,
so.
but I do know.
Nothing retroactive with the bill either, that's pending,
Yeah.
right?
I hope they're retroactive.
Oh.
Well, then we can go after you for that.
Yeah,
Yeah, no, hopefully, because it's out of the ordinary, but
yeah.
thank you for coming in.
Thank you for
Thank you.
supporting us. Thank you.
Okay, fiscal year school budget liaisons.
Budget time.
No.
School's asking if there's a member of the board that wants to participate as their liaison. FinCom has Larry Morrison.
Yeah, he's
He's the guy
been doing it for quite a while.
since, so.
When do they meet?
This one says Saturday, January 29th, at 9 a.m. at Tantasco Junior High, and Monday, February 7th, 6 p.m. to be determined.
I'll go.
Okay, somebody want to make a motion then to name Ian our liaison to the school?
I will make a motion to name Selectman Ian Dunnigan as liaison to the Burgess School Committee for the 2022, I guess it would be, or 23?
23.
Yeah, 2023 budget hearings with the school committee.
Okay, it's for both schools.
Oh, for Union 61.
Yeah, because
For both Burgess School Committee and Tantasco Regional School Committee. My apologies.
that's okay, we pay for both. Is there a second?
I'll second that.
Discussion? All in favor?
I'm not voting against you, I'm going to abstain. They're short on subs, so I've done a little bit of subbing for them. So I'm not going to,
It's really not much of a,
no, but I just feel like I'll stay away from the school committee altogether while I do that. And I might say they're doing a great job over there, the kids and everything, and the social distancing, and it's a really excellent school. Just give them a little plug while I'm here.
Yeah.
But anyways, I'm just going to abstain.
it always has been.
Yeah.
That's why we went from 3,000 people to 9,000.
They only release the best and brightest, right, Jace?
Well, let's get the boots out. Okay. So, thank you, Ian, again.
Thanks, Ian.
Okay, next, change of manager for Heel Sturbridge.
Yes, I got a letter today from Trish Fass at Heel. They are changing managers under the HCA. The board has discretion over the approval of the manager. If you would like, we can invite them back to the November 1st meeting so you can meet the new manager or approve this or some other course of action that you'd like.
What's the board's tendency?
I have no problem with them approving the
Yeah.
manager. I mean,
Yeah, I don't have an issue.
No. Okay, somebody want to make a motion then?
It would be Kimberly Avello as the new manager.
I'll make a motion to approve Kimberly Novella as the new manager of Healing.
Yeah, she's getting promoted from assistant manager to dispensary manager.
Good for her.
I'll second Chase's motion.
Any discussion? All in favor? Okay. Okay, next we have correspondence.
Right. Correspondence, September 30th, 2021, notification to abutters under the Wetlands Protection Act. October 1st, 2021, the Dirt News from the Garden. Letter from Joe C., President of the Community Food Collaborative, to Jeff Bridges. Various dates, letters opposed to the proposed equestrian center. Wendy Hollis, October 7th, 2021, 11:01 p.m. Wendy Hollis, October 7th, 2021, 11:05 p.m. Wendy Hollis, October 12th, 2021. Karen Elger, October 5th, 2021. Karen Elger, October 11th, 2021. Lori Stokes, October 6th, 2021. Lori Stokes, October 9th, 2021. Jenny Laridan, October 11th, 2021. Josephine Nikita, October 11th, 2021. Michelle Panarola, October 5th, 2021. Barbara Noon, October 6th, 2021. October 13th, 2021. Message from the Mayor of the Borough of Dudley, England, and the Stourbridge Rotary Club.
Okay, anyone else have any other?
I do.
Mary?
I'm going to add our, Jamie and my October 5th letter to the Gaming Commission, of which all select people and Jeff Bridges was sent a copy, as well as George and Davis and Jonathan Silverstein. And we got an anonymous letter or note from the Horse Racing Wrongs, undated.
Well, why add it?
That's a good picture of you.
Well, it should be, it's 10 years old. But I mean, seeing as Mary brought it up, this stuff drives me nuts, that people don't put their name on things and they get things totally wrong. Blanchard's longtime friends and recipients of campaign contributions from the developers behind this project. Look for the planning board and the Board of Selectmen to endorse this project in the coming weeks. First of all, they know so little about government. Planning board is appointed. It's not elected, so you don't do any campaigning. Charlie hasn't been on an elected board in 15 years. Him and I neither know these people till they came before the board. Plus, I am not head select woman. We are selectmen by charter until it changes. But, I mean, it's garbage. If you want to disagree with people, have facts. Do it friendly, but I do like that picture. It was a campaign.
I thought you looked great.
That's what everybody said. It was a campaign. It was a campaign picture.
And I just want to say I don't disagree, and that's why I just referenced who it was from and left it at that.
Yeah,
but
well, I'm glad
it's
you
up
referenced
to you.
it, because-
I just,
And they're using the town hall address as the return address on these.
Yep.
Yeah, I noticed that on the envelope I got.
Yeah, I mean, hey,
It's Jeff.
Jamie, in your absence, I did add to correspondence, but because for some reason it wasn't on it, what, your letter and my letter to the Gaming Commission, of which everybody was sent a copy.
Thank you.
Should have been part of the correspondence.
okay, next we have minutes. Okay, we have the minutes of September 29th. Anyone have any corrections?
Hold on, those aren't the ones at the public house. This is
No, this is,
the week after. I don't think I had any changes.
okay, Jeff, I do believe on page 179, though, Article 46, Mary hadn't come in for that vote yet. She missed the first two votes.
Yeah, it says 400. Chair Dowling, Vice Chair Dowling absent at the top of page 179,
Yeah, that's for that one,
but that is 46.
but for 47.
I did miss two.
She was, that's 4 votes there, too.
Yeah, but it just doesn't reference.
Oh, that's fine. Not a problem.
Okay. Does anyone else have anything on those minutes? Okay, somebody want to make a motion to approve as amended?
I'll make a motion to approve the minutes of September 29th, 2021 as amended.
Is there a second?
Second.
Any discussion? All in favor? Okay. I don't know why that's coming so loud.
Just popular tonight.
It's a family discussion. Granddaughter got a new job.
Congrats.
Well, she's going to school too. Okay, minutes of October 4th.
Yeah, just a question. On page 195, we couldn't get Trish's last name, maybe someone else.
It's Barassa.
Barassa.
Bourassa.
All right, thank you.
Also above there, that's not Sean Landsman, it was Jeff Langevin.
Jeff, what?
Langevin,
Langevin.
L-A-N-G,
Yeah.
Langv.
G-E-V-I-N.
G-E-V-I-N. Thank you.
And then on page 196, there was blank for Tricia's last name. Also, that other blank was, should be Mary Dowling. She said that.
I'm sorry, where are you, Mary?
Page 196.
196.
Thank you.
And one other little grammar on page 197. After, well, the paragraph, the 3-line paragraph there under the motion and vote, that first line, it says, Selectmen, we not being fair. It's where,
What page? 197.
yeah. See that?
Not being fair, it's not, should say what?
Instead of we not being fair, W-E
Oh,
apostrophe
Or
R-E.
not being fair.
Contraction. Okay, does anybody else have anything?
Wait a minute, I thought I did, I'm sorry. Motion to reconsider. Okay, before the motion to reconsider, can we add a sentence?
What page, please?
Page 196. We consider our confirmation pending the hiring. Anywhere before that, M. Dowling stated that with regret, allowing the appointment to move forward would be setting up the applicant for failure under the current circumstances.
That wasn't enough.
Yeah, I know, but I just decided to put it before the actual motion to reconsider. And then I had one change, and I don't know if it's going to require Jamie to agree, but on page 194, under old business, Chair Dowling stated that she does not want to be associated with approving of the location. Selectman Goodwin said he was angry and that the town is rushing to do this and said it's unacceptable. Then it says Vice Chair Dowling stated that she would write a letter to correct this issue. And I have that Selectman Goodwin stated that he would sign the letter as well.
That all sounds right to me, yes.
Okay. So,
Okay, is there a motion to approve as amended?
So moved.
Second?
Second.
Okay, discussion?
Yep.
All in favor? I could keep you here all night. Okay, and then Mary had asked for the minutes of September 13th to be held.
yep. I have one sentence to add. I'll let somebody else start. I wrote it somewhere and I can't find it.
I don't have anything.
I don't have those this evening. I can put them in the next packet.
Well, she said there's only one sentence.
Okay?
We'll hold her to it.
Oh, yeah, no, it is. It was all about what I said tonight. Well, you know what? I can't find it, so I'll just wing it, but, okay.
Want to email it to me, I can bring it next time.
Oh, I'll just say it out loud. It's, I can email it too, but just so people hear it. During the discussion, M. Dowling requested that the Board of Selectmen be given the opportunity to review the application before it was filed. The applicants agreed to this request.
Okay, is there a motion then to approve as amended?
Second.
Discussion? All in favor? Okay, citizens.
Who made the motion? Jamie made the motion.
I mean, Chase seconded it.
Chase, okay.
It was 5-0.
5-0.
Okay, citizens forum.
Nobody?
Okay, motion to adjourn?
I'll make a
I'm
motion.
sorry, I got one thing to say. I'm sorry, I told this resident I would bring it up.
I think we did this last
I
week.
know, we did all get a memo from a resident in the Cedar Street area about her desire, as well as a few other neighbors, and we got to, at some point, discuss it one way or another, to purchase some of the land that she's asserting is a buffer around 70 Cedar Street. I think we all got that
Yes.
a few weeks ago.
I don't remember.
You don't recall?
No.
Yeah, yeah,
okay.
different ones wanted to.
I will
purchase
forward
lands.
it. I did get back to her, she was going to try to come before us, and I did say, I think that it's subject to the procurement.
She's right here.
Oh, I didn't,
Tonight is not the night after how long this meeting has gone.
oh, I didn't, I'm sorry, I didn't recognize you back there. Okay, so,
Yeah. I spoke to Jeff about that because it's a long process. The town, first of all, has to vote to sell the land.
right, it's
And then-
procurement
Yeah,
chapter.
and then the land would have to go out for bid. You can't just pick and choose.
Oh, no, I did, I had responded.
I'm very familiar with the process, and that's why tonight is not the night to address the board after how much you've all been through tonight, so I did not bring it up.
Thank you, but years ago, we were here till 10:30, 11 o'clock.
You can get actually on the agenda, so you don't have to stay till the end of the night for citizens forum when you want to do it, though.
Do you want to put it on the
Contact
agenda for the
Mary.
next meeting?
When the time is correct, I will do that and make sure that
All right.
Okay, motion to adjourn.
I'll make that motion to adjourn.
I will second that motion to adjourn.
Discussion. All in favor? Okay, now I gotta clean this mess up.